All right, Mrs. L, how are you? Mr. Anid, Mr. Carter? Where are we starting?
Your Honor, I believe we are ready on the Tashana Hawkins case.
Tashana Hawkins.
If we're ready on the remainder of the final pre-trials.
Okay.
Locations of defendants.
So we'll start with Ms. Hawkins.
You're all right, Judge. Am I? Yeah, you're all right.
All right, so we're on the record in docket 24-03081. That is people of the state of Michigan versus Tashana Hawkins. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Carter.
May it please the court, David B. Carter Jr. on behalf of Ms. Hawkins, who is present and standing to my right.
And ma'am, you are Tashana Hawkins, is that correct? Thank you. This is the time set for a final pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the necessary witnesses in the people's case have failed to appear. We attempted to send a subpoena to them. However, I'm not sure that subpoena successfully made it to them, as I believe we had the wrong address, but they were unwilling to provide us with an updated address for that subpoena. At this time, we do expect a motion from the defense.
Did you have any contact with the complainant?
We did. That contact was when we were, that updated address was refused to us.
Mr. Carter.
Thank you, Your Honor. Normally, I don't ask for dismissal if they have service problems. Since it indicates that the complaining witness is unwilling to cooperate with the new address, I'm compelled to ask for dismissal at this time.
All right, I will enter. Thank you, Megan. All right, so Ms. Hawkins, I'm based on your counsel's motion for dismissal without prejudice, which means that people could reissue if they choose to, but it's really a default position. The case would be dismissed. Realistically, the case is dismissed based on the people's inability to proceed. And there was more than just a promise subpoena. It appears that there was unsuccessful contact with the complaining victim. So I am going to sign the dismissal without prejudice. I would continue, there's a no contact order. I would continue that with about 4 hours, just let it purge from the computer system. There's also a GPS, and you'll want to go back to the Ingham County Sheriff's Department to get the GPS removed. I believe the private agency does it right there, but we'll actually email the private agency to make sure they know you're coming.
Okay.
All right. That should be done at your, and you have it on and you want it off. Okay. so probably this afternoon. Okay. All right. Anything else for the record in 24-03081, Mrs. L?
Not for the people.
Mr. Carter.
Not for the defense.
All right. Thank you. You're all set, Ms. Hawkins. Thank you.
No contact.
Okay.
You want to go to Armstrong? You just want to start at the top?
Yep.
All right.
He's on Zoom with explanation.
That iPhone 3.
Hello?
All right. So you're Jason Armstrong, sir?
Yes, sir.
All right. I'm going to have you renamed. I'll let Megan do that since.
But I can put on the record now or later. He went to the wrong courthouse is what he indicated to me.
All right. All right. So we're on the record in docket 25-01458. That is people of the state of Michigan versus Jason Armstrong. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Ned.
George, APD on behalf of my client is appearing via Zoom.
And sir, you are Jason Armstrong. Is that correct?
Yes, sir.
Yeah. You can hear me all right, Mr. Armstrong?
Yes, sir.
And you're supposed to be here in person for the final pretrial, and you're here via Zoom. Your counsel's indicated that you went to the wrong courthouse. Is that correct?
Yeah, I went to circuit court instead of district court.
All right. And then you decided to go home and Zoom in?
And I'm walking right now, so
Where are you walking?
Was gonna walk to district court until my prosecutor or attorney called.
Sorry, I didn't catch that.
I said I was walking to district court until my attorney called and said I could do it boom.
All right. All right. Mrs. L, how are we proceeding today?
Your Honor, in all honesty, I would ask for a little bit of time for Mr. Armstrong to appear in person today. At this time, the necessary witnesses are not here. However, I believe it is important for the defendant to be present for his final pretrial.
But Mr. Armstrong, you can make it to district court. Mr. Armstrong?
Aaron, how much time does he have?
We're on the dock until about 11. So I know the AG is coming at 11 for search warrant. So, but we've got hearings to 10:30. If you want to contact him, have him come in.
Okay.
All right.
Just for the record, I did not tell him not to come. I said, join on Zoom if you can.
Right. I assumed, but we'll see.
Okay.
So, Mr. Armstrong, your public defender is going to get a hold of you. Okay, sir?
Okay.
All right. So Mr. Ned will be in contact with you, and then we'll handle your case.
All right.
All right. Did you want to go on this Nabia Davis?
Yes, I
Yes,
think we
Your
can
Honor.
go on that.
All right. So we're on the record in docket 25-01512. That is people of the state of Michigan versus Nabia Davis. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Ferries, who's appearing on behalf of Ms. Navia Davis, who I believe is appearing via Zoom. My notes from the previous court hearing reflect that she was given permission to appear via Zoom.
That's correct. I did indicate Zoom was appropriate for this case. And ma'am, you are Nabia Davis, is that correct? Ma'am, you are Nabia Davis? Usually I'm on mute, but I'm off of mute. Miss Davis, I can see you light up. So are you
I'm sorry,
Nabia
my
Davis,
phone.
ma'am? Okay, you are Nabia Davis,
Yes,
is
Your
that
Honor.
correct? All right, all right.
Yes,
And
Your
you can hear me all right, Miss Davis?
Yes, I can.
All right, Mrs. L, this is the time set for a final pretrial in the matter. How are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were properly subpoenaed for today's date, and we did have contact with them. They indicated that they did not want to move forward at this time. We do expect a motion from the defense.
Thank you, Your Honor. Given that information from the prosecutor, we would be requesting the court dismiss this case at this time. And I would simply request that a copy of the dismissal be mailed to my client, Your Honor.
All right. So I will entertain at the motion of defense, a nollie pros or dismissal. Thank you, Megan. All right, Ms. Davis, I'm in possession of an order of acquittal or dismissal based on Mr. Harry's motion. The people are unable to proceed today. The complaining victim is not on board, was subpoenaed, and any contact has been unsuccessful. So the case is going to be dismissed without prejudice. That means that people could reissue if they choose to, but realistically, for our cases today, the case is dismissed. And I have the Sadie Court address as a notification. Is that still a good address for you, ma'am?
Yes, Your Honor.
All right. Then this order of acquittal will be sent to that Sadie Court address. And that's for your order of dismissal. There's a no contact order. You should give about 2 or 3 hours to purge that from the system. And there's no GPS. Anything else for the record in 25-0512, Mrs. Up?
Not the people.
Mr. Harris.
Nothing to defense, Your Honor. Thank
All
you.
right, Ms. Davis, do you have any questions of me? Ms. Davis, you still there?
Yes, I'm sorry. My connection is messing up.
All right, you're all set, ma'am. Thank you for your appearance today.
Thank you. You too. Have a good day. I'm sorry.
You too. We have,
I believe we're ready on Mr. Ibrahim Kumbakwa.
okay. All right, so we're on the record in docket 25-00975. That is People of the State of Michigan versus Ibrahim M. Kumbakwa. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Kumbakwa, who's standing to my right, Your Honor.
And sir, you are Ibrahim M. Kumbakwa, is that correct? And is that pronunciation correct? Okay, all right. No, I want to make sure I get it right. Is the M pronounced or is it just Kumbakwa? Kumbukwa. All right. Kumbukwa. All right, this is the time set for a final pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were properly subpoenaed for today's date, but we have not had any successful contact with them. We are not sure why they are not here today. We do expect a motion from the defense at this time.
Mr. Harris.
Yes, Your Honor, given that information from the prosecutor, we would be asking that the court dismiss the case at this time due to the failure of the necessary witnesses. I would ask that a copy be provided to my client, Your Honor.
All right. Thank you, Megan. I'm in possession of the order of acquittal or dismissal without prejudice based on Mr. Harry's motion from the defense for the victims were subpoenaed, but have failed to appear at this time. Is that correct, Mrs. L?
Correct, Your Honor.
All right. Pursuant to 25-00975. And that would mean that Mr. M. Kumbakwa, the case is dismissed without prejudice, which means the people could reissue if they choose to, but realistically, for our case, for our purposes today, the case is dismissed. I will sign the order of dismissal without prejudice based on the prosecutor's representations. There is a no contact order. I would give about 3 or 4 hours to let that purge itself from the computer system. There's not a GPS tether involved. And then we'll make a copy that you should keep with you just in case, okay? Anything else for the record in 25-00975, Ms. Azell?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, it's Makumba, correct? All right. We have your dismissal. Get a copy from my court officer. You should be all set, sir. And Mr. Doyle, are you here on Mr. Perez? We should bring him up if able.
Yes, Your Honor.
Yes, Your Honor. I don't know
All
if we
right.
need to waive his appearance. I believe it's going to be a motion for dismissal.
All right. I think he indicated he was. All right, so let's go on, Mr. Perez, Ms. Stepp, and then Mr. S'mores, did you need to talk to the city assistant prosecutor on Mr. Bell, or are you ready to go on Mr. Bell?
I think, well, I guess it would probably be good to talk for a moment, Your Honor. I forgot that I did have an in-person at 10 o'clock in St. John's, so whatever
All right.
works.
Let's see, yeah, we can, 10 o'clock. So you should be all right. Let's call the other cases, then I can put you in a room with her.
Thank you.
All right, so we're on the record. Mr. Doyle, we'll call your case on Mr. Perez. And you've indicated Mr. Perez is incarcerated, has been brought over, but will waive his appearance for this hearing. Is that correct, Mr. Doyle?
That's correct, Your Honor.
All right, so we're on the record in docket 24-00289 and 24-01055. We can call those, do you want to call those together separately, Mrs.?
We can call them together.
All right. 24-01055, that's people of the state of Michigan versus Miguel Perez. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Doyle.
Good morning, Your Honor. Dan Doyle appearing on behalf of Miguel Perez.
Thank you. This is the time set for a final pretrial on both matters. Mrs. L, how are we proceeding? We'll start with 24-00289.
Your Honor, at this time, the necessary witness for this case has failed to appear. We did send a subpoena and we did leave a voicemail for them. They have left us a couple of voicemails in return. We have not had successful contact since then. At this time, we do expect a motion from the defense.
All right. As to file 24-00289, Mr. Doyle, do you have a motion at this time?
Yes, Your Honor. We ask that this case be dismissed.
All right. So we'll ask for a dismissal without prejudice on 24-00289. Thank you, Megan. And so I'm in possession of the dismissal without prejudice on 24-00289. You'll let Mr. Doyle, you'll let Mr. Perez know that this means the case could be reissued if the prosecutor reviews this and decides it should be reissued. If not, then Mr. Perez, this case is dismissed pursuant to dismissal without prejudice. And you'll explain that to Mr. Doyle?
Yes, Your Honor.
All right. I am dismissing without prejudice docket 24-00289. There's no GPS. There's a no contact order. So as you know, Mr. Doyle, he should wait about 3 or 4 hours before let that purge from the system.
Yes,
And
Your
we'll also go on 24-01055. Appearances, we've done the appearances for the record. Mrs. L, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. There was a proper subpoena sent. We have been playing phone tag with the victim. At this time, we do expect a motion from defense.
Mr. Doyle.
As such, we would ask for a dismissal of the case without prejudice because the prosecutor is unable to proceed.
So I will once again, I'm in possession of the order of acquittal or dismissal based on the defendant's motion to dismiss without prejudice on 24-01055. And I will sign the order of dismissal. There is a no contact order concerning this matter, and so you should give about 3 or 4 hours for that no contact order to be purged from the system. There's not a GPS on this file. And you'll explain the same to Mr. Perez. Is that correct, Mr. Doyle?
Yes, Your Honor.
All right. All right. I'm going to sign the dismissal without prejudice, which means that people could reissue if they choose to. But for our purpose today, the case is dismissed. Mr. Perez is incarcerated, so we're doing this without him being present. My court officers indicated that she'll explain to the jury why Mr. Perez was not brought up. All right, Mr. Doyle?
Yes, Your Honor.
And it sounds like you had talked to him already before on this.
Yes, I have.
All right. Anything else for the record in 24-01055, Mrs. L?
Not for the people.
Mr. Doyle.
No, Your Honor, thank you.
All right, we're all set. Thank you for your appearance today. You're all set, Mr. Doyle. Is it Brianna Step?
Yes.
All right, so we're on the record in docket 25-01473. That is People of the State of Michigan versus Brianna Step. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Ned.
George Annette, APD on behalf of my client who's standing to my right.
And ma'am, you are Brianna Step?
Brianna Step.
Brianna Step, thank you. This is the time set for a final pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. We have sent a subpoena, and I did confirm that subpoena was received. We did have successful contact with the victim. Based on their non-appearance today, we do expect a motion from the defense.
And our motion to dispense without prejudice and a notice for my client, please.
All right, I'm in possession of an order of dismissal based on the people unable to proceed. The victim was subpoenaed, accepted the subpoena, and then failed to appear today. So this is going to be dismissed without prejudice, which means the people could reissue if they choose to, but realistically, for our purposes today, the case is dismissed. All right, ma'am. There is a no contact order in the file, so you should wait for about 3 or 4 hours to let it purge from the system, and I'll give you a copy of this for your own records.
So I can go home after this.
What's that, ma'am?
So I can go home after this.
Yes, you can go home after this. I would just avoid contact for the next few hours,
Okay.
because you're gonna have to show them this, because it's gonna take some time for the computer system to purge it. But you should be all right.
Thank you.
Thank you. All right, so that is a dismissal without prejudice. Anything else for the record in 25-01473, Mrs. L?
Not for the people.
Mr. Net.
Yeah.
All right, you're all set, Ms. Stape. I would get a copy of this for your records, all right, or for
Okay.
yourself.
Thank you, Your Honor.
You're welcome. And then, did you want to join us? We have Mr. Alvarez. Then we have, you want to meet with Mr. Smorth on Bell.
Oh.
Yes, I'm realizing, I do not have.
I might not be able to
I don't have a case file for that.
Bell?
Or at least I'm not able to.
7-9.
It's like
I can- If I may, Your Honor, weigh in on that for just a moment.
9-7.
Yeah, go ahead, Mr. S'mores.
Thank you, Your Honor. I was just going to quickly say, as a practical matter, I do not see any, the lab work, any blood work in the file, so I'm not sure if we'd be able to proceed today, even if we could resolve it. But if the court will call.
I think this was initially set on an ordinance day, is that correct?
Yeah, I think it's a city case, but it's still labeled SD with the case suffix being a state case. So I did receive the discovery from the city attorney's office and not the prosecutor's office. And the prosecutor's office, Ingham County Prosecutor's Office, did advise that they thought it was a city case as well, that they'd be handling it. But I know on the court's docket, it still has the SD suffix or code.
I see the SD suffix, and you don't have a file yet.
I don't have a file.
Okay.
So Mrs. L doesn't have a file yet. I think we're still treating it as a city case, although you'll get your discovery from the people, I would think, once.
I usually,
Or this,
if it's our case, we already have all of this stuff because we're charging it.
I think it was labeled initially a city case.
I did receive the discovery from the city attorney's office. Oops, I don't know. But I don't, but there are no lab reports yet anyway, regardless of even if we had this situation straightened out, so I wouldn't be able to proceed today, even if we could resolve it, but that's our status. I'm sorry for not calling on it yesterday.
No, that's all right. I think it was written incorrectly.
It was.
Yes.
It was written as a statute.
Yeah, I think it was written as a statute, but it's a city case.
I think so.
I think so, but I'm not sure.
I believe Ms. Taylor was speaking to somebody at the prosecutor's office about this. And I clearly don't know what the resolution was because I'm so confused.
We can adjourn this to see what agency is you're seeking additional lab reports from, because right now, I don't know.
Very
I know
well.
Mrs. L doesn't have a file, and I know it's labeled a city case. But I think the city is not providing full discovery on that.
I think that's.
The lab reports would take some time. Is that correct, Mr. S'mores?
That's my understanding. I know this case, I think dates back to February, March, so they could be ready. I just
Okay.
haven't seen them yet, but that's where we are. And just for the court's just to notify the court, I am going to be out of, I don't know if the court was contemplating just a week adjournment, but I am out of town next Monday and Tuesday. So I was hoping for a 2-week adjournment
Did we
longer.
want this set on the city docket or on the state docket? Because I think we've tried it once before and we didn't know who, because it's an SD case, it's a city case.
I think it might be best to set it on the city docket. I wouldn't mind making an appearance for safety purposes on that day if you prefer.
That might not be a bad idea as a backup plan. You set it on a city date, and let's get you a date that works with your schedule, Mr. S'mores.
Okay, thank you.
Yeah. I know right now, I mean, I don't want to make a long case longer, but we're looking probably at the beginning of August.
Oh, okay, that's fine, Your
Yeah.
Honor.
So,
August 4th at 9:30.
yeah, I need the file.
Oh, I'm sorry, Judge.
All right, so we'll set it on a Monday, the 4th. So we'll set it on Monday, the 4th. On both, we have the actual file and a accompanying ticket. And we'll set for adjournment for pretrial to figure out, I think we probably get it from the city, but just make a note, Mrs. L. And we'll set for adjournment. Does that date work with you for August 4th, Mr. S'mores?
Yes, Your Honor, thank you.
Okay, we'll set for August 4th at 9:30. 4th, 9:30. And that'll give everybody enough time to find a discovery, Mr. Bell. So Mr. S'mores can zealously represent you in your defense, and we'll get all the lab reports that come. I think it's a city case, but your idea is a good idea. So August 4th at 9:30. Anything else for the record in 25-01176 or the accompanying ticket, Mr. S'mores?
Just to confirm that would be by Zoom as well, Your Honor, for my client's benefit.
But Zoom is appropriate for that pretrial.
Thank you very much.
As a matter of fact, the APA might only be available by Zoom for that pretrial because it's not an APA date. We're going to set it on a city date just in case. Mr. Bell, do you have? Please keep in contact with your attorney, Mr. S'mores. We'll see you on August 4th. All right, sir?
Okay.
All right. You're all set, Mr. S'mores. Thank you.
Thank you.
All right, so we're on the record in docket 25-01089. That is the people of the state of Michigan versus Peter Ding Majak. Will the parties please introduce themselves for the record? This is Al.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Ned.
George Annette, APD on behalf of my client is saying to my right.
And sir, you are, correct my pronunciation, Peter Ding Majak, is that correct?
Correct, Your Honor.
All right, thank you. This is the time set for a pretrial in the matter Mrs. L, how are we proceeding?
Your Honor, at this time, we are hoping to start screening for sobriety court. So we are asking for an adjournment of about 30 days to get that screening process started.
So that specialty court is with Judge Buchanan.
Yes.
And so we had another case go this route. Judge Buchanan would take the plea, et cetera, and it'd go through, but it takes some time for that to happen. It takes a process. So we'll adjourn. You think 30 days will be the start?
I believe that should
It's a
work.
good start. Your
Is that a fair statement, Mr. Net?
Yes, Your Honor.
We'll adjourn for 30 days to, yeah, let's. Is
This
this,
is the second, because that's the plea. If they graduate, sobriety court is pled to the second. So I can only felony cases.
Okay.
I can confirm that with, let me message your reporter.
let's see what she takes. This is a,
OWI second, Your Honor, and if it doesn't work, then maybe I'll talk to the prosecutor about doing a 54B sobriety court, because I know I'm almost certain they take seconds.
I do believe 55th takes seconds as
55th
well.
may take seconds, and I don't know what, but that would be the ultimate plea with the second, the misdemeanor plea down from the felony, I would assume.
So for, if they go in with a second, the plea offer at the end would be the OWI first if they, upon completion.
And that's in East Lansing or is in 55th?
I believe both programs do that.
Okay, all right. So let's adjourn 30 days out because there's some room depending on what specialty court. I do think that the 54A specialty tour court goes third to second. There may be some room in second to first, but we'll adjourn for 30 days to,
July 22nd at 9 PM. Kelly didn't answer me. They only take felonies.
okay. So we'll have to look at 54B and 55th as a specialty court for July 22nd at 9 o'clock. All right, so we'll adjourn for 30 days to see what options are available for sobriety court in 55th and 54B. And we'll be back on July 22nd at 9 o'clock. Anything else for the record in 25-01089, Mrs. L?
Not the people.
Mr. Net?
No, Your Honor.
All right, Mr. Ding Majok, we'll see you on July 22nd. If not, contact Mr. Ned because the process might start to be going into another court, okay?
Okay.
All right.
Me? My office in Mason. Okay, not at Mason, South London.
All right, did you need some time to check on witnesses, Mrs. L, or?
No, I believe we're ready on 2 more if
Okay.
you are.
We're good.
All right, we're ready on Yates and Alvarez. Yates is here in person. If we could call his case first.
Is that Mr. Harris or Mr. Annette?
That is mine, Your Honor. I am on both Alvarez and Yates.
All right, we'll call Alvarez second. All right, Mr. Yates, we'll call your case. So we're on the record in dockets 20-02461. That is people of the state of Michigan versus Guadalupe Yates. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Yates, Your Honor.
And sir, you are Guadalupe Yates, is that correct?
Yes, sir.
Thank you. This is the time set for pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, I believe at this time we are asking for an adjournment to continue the assessment process for sobriety court. There were some financial difficulties as my understanding, and I will defer to Mr. Harris to make a further record.
Mr. Harris.
Yes, Your Honor. I've been working pretty closely with Mr. Yates, trying to find options for him to get the assessment done as his finances are very limited. We were recently able to get him an assessment with CMH that would meet that is something he could do with his financials. He currently was able to get that assessment scheduled, and according to him, that assessment is scheduled for tomorrow at 2:30 p.m.
All right.
So we would be asking for about 30 to 45 days adjournment to allow time for that assessment to be done, and then a copy of that assessment to be provided to myself and the prosecutor so that we can consider a possible resolution at the next court date, Your Honor.
All right, and then is this being addressed, is this is a second also, is this being reviewed for specialty court also?
It is, Your Honor, and we will review it for 54B or 55th.
Okay, same issue. But so the assessments tomorrow, we'll adjourn for 30 days out. And this is the last adjournment. Rather than, we'll set it for final pretrial. We'll adjourn for 30 days out too.
For final pretrial,
No, this is your regular pretrial.
this case is at 97 days, 9 o'clock on July 22nd.
So it'll be July 22nd at 9 o'clock. All right, so this is set for July 22nd at 9 o'clock. And then 54B and 55th can be addressed also. Anything else for the record in their specialty courts? Anything else for the record in 20-02461, Mrs. Al?
Not the people.
Mr. Harris.
Not from the defense, Your Honor.
All
Thank you.
right, Mr. Yates, keep in contact with your attorney, Mr. Harris. We've set for July 22nd at 9 o'clock. There may be a process that you go through, but that date should be July 22nd, and then we'll go from there, okay? All right, thank you. All right, and then we have
Mr.
Alvarez is on, right?
Yep.
All right, so we're on the record. So Mr. Alvarez, you can, or Jesse Alvarez, you can unmute. Jesse Alvarez, you can unmute.
Hello?
Thank you. Yep, I can hear you. So we're on the record in docket 25-01052. That is the people of the state of Michigan versus Jesse Alvarez. Will the parties please introduce themselves for the record? This is Al.
Thank you, Your Honor. Gabrielle Lethal, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Alvarez, who is appearing via Zoom, Your Honor.
And sir, you are Jesse Alvarez, is that correct?
Yes, sir.
And you can hear me all right, Mr. Alvarez?
Yes, sir.
Thank you. This is the time set for a pretrial in the matter. Mrs. L, how we proceed?
Your Honor, it's my understanding that today defense is asking for an adjournment. As always, in this case, we have extended the free offer of a license, a valid dog license would equal dismissal of the case. Mr. Alvarez is trying to get that valid dog license, and there is a new clinic coming up shortly, and I'll have Mr. Harris make a record of the date of that.
All right,
So we are asking for an adjournment for that.
Mr. Harris.
Yes, Your Honor. Since the previous court date, my client has been working hard to try and get the license. He indicated he has been experiencing some financial difficulties as he recently lost his wallet. He did indicate that he believes he should have some money coming in that he can put towards getting the license in the next few weeks. And he also indicated that he is going to be signing up for the Ingham County Animal Control's dog vaccination clinic, currently scheduled for July 9th.
July 9th.
And he's going to be scheduling an appointment for that later today. So it is my belief that it is very likely we will have compliance reached in the next 30 to 45 days. So we would be requesting an adjournment.
All right, I will allow a last adjournment. We'll set it for final pretrial. I think that's a good idea. We'll set it 45 days out. The vaccination clinic is July 9th, so we'll set it past July 9th date to give plenty of time. But that would be the last adjournment for the final pretrial. Mr. Alvarez, you should be here in person on this date for the final pretrial date. We'll set you in person, and you can provide whatever paperwork you have to your attorney at that time. All right,
Okay.
sir?
Okay, sir.
So we'll set this for final pretrial for compliance purposes on July 29th at 8:30. All right, so we've set it well after the July 9th vaccination clinic. It'll be set for July 29th at 8:30. Anything else for the record? Anything else for the record in 25-01052? Mrs. Al.
For the people.
Mr. Harris.
Not the defense, Your Honor.
All right, Mr. Alvarez, we'll see you on that July 29th date. Thank you for your appearance today.
Okay, thank you so much, sir. Bye-bye.
We'll see you. All right, so we're on the record in docket 25-01590. That is people of the state of Michigan versus Kristen House. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Carter.
May it please the court, David B. Carter Jr. on behalf of Ms. House, who is present and standing at council table.
And ma'am, you are Kristen E. House, is that correct?
That's right.
Thank you. This is the time set for a pretrial in the matter. Mrs. L., how we proceed?
Your Honor, it's my understanding we're going to be asking this to be set for a final pretrial.
Is that a fair statement, Mr. Carter?
It is, and I did secure a date.
Excellent. All right, what date are we using?
July 22nd at 8:30.
July 22nd at 8:30 for final pretrial. So Ms. House, that'll be live in person on the sixth floor City Hall of Lansing. And we've set it for July 22nd at 8:30. Anything else in regards to 25-01590, Mrs. L?
Not for the people.
Mr. Carter?
Not the defense.
All right, you're all set, ma'am. We'll see you on July 22nd.
Thank you.
All right, where did you want to go next, Mrs. L?
Mr. Armstrong is here, so we could call this case.
All right. All right, so we're on the record in docket 25-01458. That is people of the state of Michigan versus Jason Armstrong. Will the parties please introduce themselves for the record, Mrs. L?
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Ned.
George and Ed, APD on behalf of my client, standing to my right.
And sir, you are Jason Armstrong, is that correct? Thank you. This is time set for a final pretrial today. Mrs. L, how are we proceeding?
Your Honor, at this time, the necessary witnesses have failed to appear. We did not get a successful subpoena to them. However, we did have successful contact. In that contact, the victim was unable to appear today in person due to having a young child at home. I did ask if she would be able to appear via Zoom. She indicated she would try to. As far as I'm aware, she has not appeared via Zoom today. We do expect a motion from defense.
All right, and that the complaining victim who was supposed to, or who was going to try to appear via Zoom was Miss Secord, is that correct?
That is correct, Your Honor.
Mr. Annette.
Given that, Your Honor, I'd ask for a motion to dismiss without prejudice at this time. Thank you.
Right, so I will explain to Mr. Armstrong, I'm going to grant the motion to dismiss without prejudice. That means the people could reissue if they choose to, based on the inability to proceed because Miss Secord's not here today. She was explained to be here. She indicated she may be here by Zoom. She's not here via Zoom, and therefore I'm gonna grant the motion. But most of the motions I grant, I don't expect without prejudice. This could come back, right? This could come back, and if it is, then this all starts again. Okay, you'll get arraigned again. Everything starts again. I think that's fair to tell you that there's a no contact order with Miss Secord. That should take about 3 or 4 hours to purge from the system. So you should carry a dismissal with you, okay, just in case. All right. So I'm going to grant the motion dismissed without prejudice based on defendant's motion and representations made by the APA in the matter. I will sign the Molly Pros. So this may be reissued, but for our purposes today, the case is dismissed. Anything else for the record in 25-01458, Mrs. L?
Not for the people.
Mr. Annette?
May I, client, get a copy, Your Honor?
Absolutely.
Thank
So you can get a copy from my court officer, Ms. Slaviak. Good luck to you, Mr. Armstrong. Did you want to go on next to Mrs. L?
I do believe we have a couple of failures to appear.
Okay,
I don't know if you would want to just wait and call them last or.
it's up to you. I mean, there's a couple of 9:30s.
Correct. We do have Mr. Carson here. I believe we'd be ready to go on that one.
Okay. Is that a pro per or Mr. Carson's represented by?
That Mr.
me.
Annette is on the case.
All right, let's go on Mr. Carson. All right, so we're on the record in docket 25-01675. That is people of the state of Michigan versus Henry Carson. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Ned.
Yours in it, APD on behalf of my client standing to my right.
And sir, you are Henry Carson, is that correct?
Yes, Your Honor.
Thank you. This is the time set for pretrial in the matter. Mrs. L, how we proceed?
Your Honor, it's my understanding that we are going to be leaving this set for a final pretrial.
Is that a fair statement, Mr. Annette?
Yes, Your Honor.
All right. So we'll set for final pretrial on
July 17th, I'm sorry, July 15th at 8:30.
July 15th at 8:30. All right, so it's set for a final pretrial on July 15th and 8:30. That is live on the 6th floor of City Hall, Lansing, just like we are here today. And then we'll put this for final pretrial on that date. Anything else for the record in 25-01675, Mrs. L?
Not for the people.
Mr. Annette?
Would you entertain a GPS motion, a bond amendment motion here?
I will entertain a modification of bond, Mr. Annette.
Your Honor, my client is 64 years old, has not had any troubles in about 10 or 12 years of what he reports to me. This is an incident where it's reported in the report that he called the police and he was the one arrested. I'd ask, based on the circumstances and his health condition, he does have seizures and uncomfortability with the GPS. I'd ask, and there's been no allegations whatsoever of any issues in this case, Your Honor. I'd ask for it to be removed at this time.
Mrs. L.
Your Honor, the GPS tether is on, I believe, to ensure that the defendant does not return to the address that the victim resides at currently. I have not gotten a change in address from the victim, and I do believe that the defendant's home address is the same. I have concerns about if the tether is removed, that address would be avoided at the best of their ability. So that is where we stand, Your Honor.
All right. I'll deny the motion for bond modification. The GPS was ordered by the magistrate on GPS and no contact. I don't see anything that changes. There was a request from the people, GPS tether with victim notification and exclusion zone if possible. This can be obviously revisited at the final pretrial, but I'll deny the bond motion at this time. So deny the bond motion for modification. We'll leave the, so you continue to have a GPS and the no contact order with Kenneth Carson. Anything else for the record in 25-01675, Mrs. L?
Time for the people.
Mr. Annette?
No, Your Honor.
All right, Mr. Carson, you're all set. We'll see you on that July 15th date.
Thank you, Kevin. Can we do Melissa Tackle? She's a failed to appear.
Yeah, we can do, we've also got a Porter. Is that a?
Your Honor, Porter is also a failure to appear.
All right, let's do Porter. We've got Mr. Annette, so let's do Tackle, and then we'll do Mr. Porter. All right, so we're on the record in docket 25-01397. That is people of the state, I'm sorry. We're on the record in 25-00548. That is people of the state of Michigan versus Melissa Tackle. Will the parties please introduce themselves for the record? Ms. Azell.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Annette.
George Annette, APD on behalf of my client who's not here today.
All right, this time is set for 10 o'clock.
9:30.
Oh, 9:30, you're right. 9:30, it is now 10:20. And it would appear that the defendant has failed to appear for the pretrial today. I do not see Melissa Tackle in the Zoom courtroom. Nobody answers by that name in the hallway or the physical courtroom. Ms. Zell, how would you like to proceed?
Your Honor, at this time, the people would request a bench warrant in this case. This is a non-assaultive case, and normally we would ask for a 48-hour hold there. However, it's come to my attention that Ms. Tackle also failed to appear for a city case yesterday, so we would ask for a bench warrant. Thank you.
This is the second fail to appear. We had her once yesterday for typically it was a property violation. She does indicate that she's homeless on this. So, Mr. Annette, have you had any contact with Ms. Tackle?
I have not, Your Honor. I have tried.
Okay. Because yesterday we had another file, a city file, and she was bench warranted with a 48-hour hold, which is quickly running out, I'm going to issue a regular bench warrant. We don't have an actual updated address for Ms. Teckle. I have an Indiana Avenue address as the last address. I also have that she was homeless. So, all right, so we'll issue an immediate bench warrant for Ms. Teckle on the file. Anything else for the record in 25-00548, Mrs. L?
Not for people.
Mr. Net? All right, thank you. That's all for the record on that file. Then we have a Mr. Porter.
Your Honor.
All right, so we're on the record. This one is 25-01397. That is People of the State of Michigan versus Jerry Porter. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Porter, who unfortunately does not seem to be here in person or via Zoom. I did try calling him this morning regarding the failure to appear, and it was advised that his number seems to be disconnected. Unfortunately, I don't have other means of getting in contact with him other than potentially trying to send a letter to his address. So I cannot explain his failure to appear today, Your Honor.
This was scheduled for 9 o'clock. It is now 10:22. I do not see Mr. Porter in the Zoom courtroom, physical courtroom, and the best of, based on the representations of counsel, Mr. Harris has tried to make contact with Mr. Porter. I do have a previous fail to appear on May 27th. Mrs. L, how would you like to proceed?
Your Honor, at this time, we would ask for a bench warrant to be issued based on that additional failure to appear that happened at the last pre-trial.
Because this is not commonly, usually there's 48 hours. There's a previous fail to appear on May 27th. So an immediate bench warrant is issued. Anything else for the record in 25-01397, Mrs. L?
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
Thank you. And then we thought Mr. Woody was an MDOC.
Yes, I spoke with your court staff, Your Honor, and my understanding is that it may be that the MDOC, I think there may have been some email that MDOC was not able to accommodate today's.
Yeah, I saw a couple of those.
But according to your court staff, the case itself wasn't reset. So I guess we would just address that on the record, Your Honor.
We know where Mr. Woody is.
Yes.
We just can't we're having some issue with getting him here on Polycom. If we don't, so we don't have to writ him out. Is that correct? Or the writ is a Polycom.
I'm looking at that.
So they couldn't accommodate today's time, so it looked like the 24th worked. I just don't know if it was set for the 24th or not. It wasn't removed from the docket.
That's June 24th.
Yes. And it also appears that I forgot to put Hinton on Polycom, so that's my fault.
Is he still in custody?
Yeah. Or actually,
I saw that he
Yeah.
bonded out.
it says as of today, he is incarcerated since May 22nd.
Do we know where?
Ingham.
Because my check of Vineland showed that he had bonded out, and when I spoke with him on 6/13 for the initial client discussion, I effectively saw and heard ICJ telling him he was getting released that day.
I don't know, maybe something new up.
Yeah,
For Mr. Woody, we have him on a city case on the 23rd at 9, so perhaps Mrs. L could pop in by Zoom. The 23rd,
I can do, yeah.
I know where Mr. Harris is going to be.
because that way maybe we can handle both cases and not have to, my guess is they tried to do it for both dates and something got lost in translation.
All right.
My best educated guess.
So do we dare set a city case on a state case, on a state? I know where Mr. Harry's going to be. He's going to be
We've
here.
been doing it all day.
We've been doing it all day. I know we're not supposed to do it, but if you join us via Zoom, we'll have everybody here.
I would be happy to do.
All
that.
right. All right. So we're on the record. We do it all the time. We're not supposed to do it all the time.
Yeah, we're not supposed to be.
But sometimes it makes for more efficiency. All right, so we're on the record in docket 25-01443. That is people of the state of Michigan versus Stephen Woody. Appearances for the record, Mrs. Zell, and then I'll make a record and then you can supplement the record. Each party can supplement the record the way they see fit. Mrs. Zell.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Stephen Woody. My understanding, Your Honor, is that he is currently in MDOC and the court tried to do a writ or Polycom connection to have him connected, but was advised that today's court date would not work. So I would be requesting that the court simply reset it for a date that would work for the connection, Your Honor.
Yeah, and that's pretty much what we're going to do. I think we're going to, we know where Mr. Woody is. He's in MDOC. And there was some indication that he was, this date or the date that was set was not going to work out. There's also a city court date. And Ms. Ezel's indicated that she will join us for the city date. And so we'll place it all on that date since we know what's coming on Polycom. And maybe we can resolve both files or set both files on that date. Right now, we just want to get them here. So we'll set 25-01443. I'm going to indicate we'll reset for city date. APA will join. And we'll set for
June 23rd at 9.
June 23rd at 9 o'clock. Mrs. L, is there anything you wanted to say for the record?
No, Your Honor, other than the fact that I have this on my calendar and I'll be present.
Okay. All right. We'll set it for June 23rd at 9 o'clock. Hopefully, Mr. Woody will be placed on Polycom and we can address both files at that time. Anything else for the record in 25-01443, Mrs. L?
Not for people.
Mr. Harris.
Not from defense, Your Honor.
All right, we're all set on Mr. Woody. And then Mr. Hinton, we just need a new date on. I think, is Hinton a PD case?
It sounded like James represented.
Yes,
Yeah,
I
all right.
represent Mr. Hinton, Your Honor.
We do not have an appearance.
I will speak with my
So we'll
office about getting that
fix
appearance.
that.
submitted.
All right, so we're on the record in 25-01662. That is people of the state of Michigan versus Johnny Martel Hinton. Will the parties please introduce themselves for the record, Mrs. L?
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Hinton. He is not here in person or via Zoom today. My understanding is that after being released from custody last week, when I spoke with him, he is now back in custody and was not put on the jail list, Your Honor.
So he is in, right now, we've got him in Ingham County Jail based on the court's information, and we'll reset this so we know where he is. If he is able to get out, because that sounds like he was picked up on something else, then Mr. Harris, you may or may not have the opportunity to tell him when the new date is.
Yes,
We will send the date to his last known address with our file, and let's see if you have the same one. That is the Bench Street address. Do you have that, Mr. Harris? BENSCH.
I believe so, Your Honor. Give me just one moment to confirm. Yep, that is the
All right.
address we have, Your Honor.
All right, and we'll reset.
Do you want me to go a week out since we can keep in custody, or do you want me to go with the regular time?
I don't know I don't know why he was picked up. But he's got a PR bond on this file. So I would think he's not in on this file. He's either on a different file or violation but he's not in on this file.
That's nothing in our report, so it must be one of the others.
Right. So set it as close to 2 weeks or more. That would at least give Mr. Hinton time to contact Mr. Harris.
Next date we have is July 15th at 9:30.
So set for July 15th at what time?
9:30.
9:30. All right, we've reset this pretrial for July 15th at 9:30. Anything else for the record in 25-01662, Mrs. L?
Not for the people.
Mr. Harries?
Not for defense, Your Honor. Thank you.
All right, that's all on that file. We have a civil matter at 10:30. And then is everybody back at 1:30? We've got a bunch of
Yes, Your Honor.
probation violation sentencings.
We've got fun afternoon.
And then we have civil stuff this afternoon. And then I don't know if you're gonna be in the loop on Thrush, but anything that you find out, let Wendy know. Okay?
Absolutely.
I can go back and ask for an.
That's because we can reschedule the date without everybody showing up, if that's what needs to be. Because that's just a review, but we're waiting for paperwork, kind of. So.
I'll reach out to Mr. Martinez.
All right.
Update I can get.
And then, ma'am, are you Monique Brown? All right. And then that is Sun Home Services, and that's Mr. Renner. Is that correct? And Mr. Kuipers, are you here on that case?
I'm here filling in for Mr. Renner, yes.
All right. You can come up, Miss Brown. I gotta pull that one out. Okay. Give me 1 second and I'll. You can have a seat, ma'am. So on base also has the same, at least on mine. I just kept it the same. Yeah, I told you that yesterday. I don't so have a motion. My last is the judgment from June 30th. Nice. I don't think I have. Not sure. All right. All right, so we're on the record in docket 2408646. That's Sun Home Services versus Monique Brown. Will the parties please introduce themselves for the record? Mr. Kuipers.
Good morning, Your Honor. Matthew Pipers on behalf of the plaintiff.
And we can barely hear you.
Sorry, Your
Mr.
Honor.
Kuipers.
Is that better?
Okay. That was better. All right. I heard it much clearer that time.
Pipers.
And he's on
Kuipers,
Zoom.
yes.
Kuipers, is that correct?
That's correct.
All right, Ms. Brown, your appearance for the record.
My name is Monique Brown.
This is the time set for a motion to set aside. It previously came from a default, which is kind of in the motion itself. That you failed to appear, Ms. Brown, on, let's see, June 2nd, 2025. The motion was placed on the record. Your motion here indicates you did not receive service. This is actually moved up to June 17th from a date that was later. I think the court did that. I don't think Mr. Kuipers did that. I think the court did that. Is that correct? I think we previously had a later date set.
It was set for today.
Yeah.
At 2:30.
No, it was set for today, but the June 17th date.
Right.
Right. It was
And then it moved up to
June 17th. Right.
Right.
So the bench trial was originally scheduled for June 17th. Motion for summary was filed. Motion for summary disposition is what was.
Yeah, Judge, my understanding
Well,
is that the
Okay, go ahead, Mr. Kuipers.
the motion for summary disposition, it was filed back in April 29th of 2025. The date that was listed on it was June 17th at 2:30. And then it looks like the court reset that to June 2nd. And at that point, it looks like the defendant failed to appear, and then the court issued an order signed June 4th.
Right, I can barely hear you. Now I'm having trouble hearing you.
Sorry, and then the court issued an order on June 4th granting the motion for summary that was heard on June 2nd,
Right.
8:30.
There was obviously a problem with the June 17th date for appearance purposes, because I think we moved it up from you to June 17th, regardless. And I think that was a court doing. I don't know if that was that was because I think I signed this. I think we did that.
So on I'm so sorry, April 29th, motion for summary disposition was filed and scheduled by civil for June 2nd. And then that was done on May 2nd.
All right.
On June 2nd, the motion for summary disposition was adjourned because an order was entered. I think the order entered in error because we did not go on the record on 6-4 or 6-2.
What was set on June 17th?
Originally, it was a bench trial.
And then we had another date set.
And they set the motion. They took off the bench trial when they entered the order.
All right.
And the motion got filed by Ms. Brown, and so here we are.
All right. So
But
I'm convinced that Ms. Brown didn't have proper service.
She did.
That we moved it around on you, which isn't fair to you. Okay.
Thank you.
So I can reset this for hearing. Ms. Brown, I'm not sure when I'm not sure what date we set it for.
Well, I have a notice to appear here.
Right.
And it was for today at 2:30.
Right.
And then I got the judgment against me.
For June 17th.
June 2nd, and then I filed the motion to set aside the
All right.
judgment.
So I'm going to reset this for hearing. I'll grant the motion to set aside. But Mr. Kuipers, did you want to speak with Ms. Brown concerning this matter? We can use this time effectively or at least make sure we have contact information proper. And then we'll set it for, I'll grant the motion to set aside the notice of hearing, or set aside the, I should say, set aside the order.
Can we get a new
So-
MSD date then?
I'm sorry, Mr. Kuipers, I can barely hear you.
Sorry, can we get a new motion for summary date?
You will.
then?
You'll get a new date for hearing, and you'll get a new date for hearing to be here, because I'll grant your motion set aside. I'm going to make that note. So grant motion set aside let's see what I have. Summary disposition was what I granted for the non-appearance. I'll indicate that the let's see. Two did not have proper notification. And then let's get a new hearing date set. And then if you choose to, if you want to, you can meet with Mr. Kuipers if he's amenable to discuss some of the legal issues concerning this matter.
Okay.
Mr. Kuipers, would you be interested in meeting with Ms. Brown after I get you a new date?
Yes, quickly, yes.
All right. We can put you on an iPad and make that happen, all right?
Okay.
But let's get you a new date. So we'll have a new hearing date is set. We'll set that. So July 15th at 2:30. And Ms. Brown, you'll get notice from my court officer. You can put it in, you can write it down, but you'll get written notice also from the
Okay.
court officer.
All right.
So it's set for July 15th at 2:30. On granting the motion granting the motion to set aside the summary disposition. And then Ms. Brown, I can put you, if you follow my court officer, she can put you on an iPad and you'll have some privacy with Mr. Kuipers, all right? All right. Mr. Kuipers, you have that date as of July 15th at 2:30?
Yes, I do, thank
All
you.
right. All right, so Mr. Kuipers, I'm gonna indicate that I'm gonna put the parties in a breakout room. And then you're free to leave once you're done there, but we'll add that. And Mr. Kuipers, you'll get a prompt to go to room 1. All right, sir?
Thank you.
You're welcome.
Can I ask one question?
Sure.
Does that mean that they're not able to like garnish my check or anything?
No,
like
the
that?
order's been put aside until the next hearing.
Okay,
Okay,
thank you.
thank you. And then Megan, I'll go ahead and put that in room 1, once you join. We're on the record in docket 22-03062. That is People of the State of Michigan versus Brian Thrush. Will the parties please introduce themselves for the record? Mr. Martinez.
Good afternoon, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
Thank you. And Mr. Leone.
Yes, John Leone here on behalf of Mr. Thrush, who stands to my right.
And sir, you are Brian Douglas Thrush, is that correct?
Yes, Your Honor.
Thank you. This is the time set for, this was a review and a delayed sentencing hearing concerning more additional information we were looking for. Mr. Martinez, you may proceed.
Thank you, Your Honor. I have been in contact with Mr. Leone, Judge, prior to today, leading up to today's hearing. Today, he and I discussed the matter further, and we met with Your Honor in chambers. I just wanted to indicate for the record that I was provided a letter from University of Michigan Health Sparrow, authored by a Dr. Darren Morse, and Dr. evaluated or performed an assessment of Mr. Thrush on May 28th, 2025. Based on the results of that assessment, Your Honor, I'm satisfied at this point that the case is appropriate to be dismissed at this time.
All right, so we will print out a nollie pros. That's your understanding, Mr. Leone, is that correct?
Yes, it is, Your Honor.
All right, we'll print out a nollie pros to be signed by Mr. Martinez. I don't know if Megan's.
She doesn't know what.
Yeah, but she's gonna take it from the printer. She does the hardest part of it, which.
Mr. Martinez, your P number, please.
69481.
And after the deferred sentence, case is to be dismissed without prejudice as a default. Based on the additional information, Mr. Lano was kind enough to submit an evidence submittal supporting dismissal on the deferred sentence, and Mr. Martinez was referring to Exhibit A from the May 28, 2025 documentation concerning Darren Morris, who wrote a follow-up concerning this matter. And this would be, so that should go to Mr. Martinez for the nollie cross. Then I'll sign the bottom of it. So we are October, we're probably 8 months into the deferral status of this case. But we've reviewed it. We've seen that the case was deferred and then referred for deferral status. This is compliance has been met in this case, and I will sign the dismissal without prejudice is really a default. That what it means is the people could reissue if they choose to. Realistically, for our purposes today, the case is dismissed, right, sir? All right. All right, I will sign the order of nollie pros. It will be available to you if you want a copy for your records. Anything else for the record in 22-03062, Mr. Martinez?
Nothing from the people. Thank you.
Mr. Leone?
Nothing from me, Your Honor.
All right, Mr. Thrush, good luck to you. You're all set.
Thank you, Your Honor. Thank you, Mr. Martinez. Thank you.
And then Mr. Martinez, you're off to East Lansing, right?
I think I have some covering for me out there right now.
All right.
So I think I'm okay, but.
All right.
Do you mind doing two?
And then Mrs. L, who did you want to call next? Yeah, we have a full docket this afternoon.
See that.
Or we can have Miss Slaviak has to get Mr. Ayers, Mr. Castillo, or Gonzalez, or Ray. Or if Mr. Ned's ready to go on anything.
I can grab it for you.
And then
Sure, is he here?
Yeah.
You ready on that? All right, we can do Marvin Phillips.
all right, Mr. Phillips. All right, so we're on the record in docket 24-02521. That is People of the State of Michigan versus Marvin Phillips. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Lizelle, Assistant Prosecutor for the people.
Mr. Annette.
George and at APD on behalf of my client who's standing to my right.
And sir, you are Marvin Phillips, is that correct? Thank you. This is time set for a probation violation hearing. Mrs. L, how are we proceeding?
Your Honor.
Or would you like to defer to Mr.
If I could defer to Mr. Annette.
Mr. Annette?
Yeah, I spoke with my client. We reviewed the recommendation and the violation. We are intending to admit responsibility to the violation.
All right, you've been able, all right, so you understand that, so may I inquire of Mr. Phillips of his probation violation, the allegations and his admission to the violations?
Yes, Your Honor.
All right. Mr. Phillips, do you understand that you have a right to a hearing? You have the right to have counsel at that hearing. You were represented today by George Sinet, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that?
Yes, sir.
It is your choice today to plead to the allegations made on the May 14th allegations concerning the probation violation. Is that correct? All right. So please raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury. All right, I'm going to end this first one. Let's see, 14. So it is alleged that on or about April 16th, 2025 at AberHealth that you tested positive for alcohol. Do you admit to testing positive for alcohol on April 16th, 2025? Yes, sir. It is alleged that from your probation officer, Nathaniel Neves, it is alleged that on or about April 18th and April 11th, that you tested positive for amphetamine, methamphetamine, and cocaine on April 11th, and it was confirmed by the lab on April 18th. Do you admit to both of those, sir?
That's right.
All right. I find the admission to the technical probation violations to be knowing, voluntarily, and accurately made. Allocution, Mr. Anid.
Thank you, Your Honor. As the recommendation states, it is clear that addiction and accountability is an issue here. After speaking with my client, he is fully aware of the situation. He wants to do the right thing and stay clean. He is not objecting to a scram tether to prevent these types of issues from happening again. He's asking for a suspended sentence as the recommendation requires. He's doing good on probation. Obviously, besides a few issues, addiction is a problem, Your Honor, as we all know with this community. We are trying to prevent it. Jail will do no good, in my opinion. And I believe I'll defer to the prosecutor on their position on it. I think in my conversation, we're both for a scram tether, so we can prevent this issue from happening. He understands that this is his third or fourth violation. And he assures that, Your Honor, this will not happen again.
Yeah, we're on previously pled to on May 6th violations. And it is these are the fourth violations. Mrs. L, I'm also under, these are only allegations at this point, but there was a positive test, recent positive test that he came back on from AberHealth. Let's see, I have a date on those. Have you seen those, Mrs. L?
I do not believe I've seen those.
This was a urine test as of, let's see if these are new or not. These are April 11th, which are part of the April 11th positive.
I do have those, yes.
And then April 18th, it was confirmed. Those were already made in the allegations. The other one was April 16th, tested positive for alcohol. and that was confirmed on April 22nd. And then there was another positive. All right, so
Your Honor, we also don't object to extending probation. I don't think that was in the recommendations. But my client has no objection to extending probation, prove to the court that he is trying to help himself.
all right, thank you. You've had the opportunity to go through the pink sheet with Mr. Phillips, is that correct?
I don't know if it's pink, but it's the probation violation recommendation.
All right, that's pink for me, and then we get sent one. Mrs. L, anything else on the record?
Your Honor, what Mr. Nate said was true. We do agree with that scram tether for those 60 days. We would push for that outpatient treatment, especially with another potentially positive test coming through. That could be a good step towards making sure probation is successful moving forward.
Mr. Phillips, is there anything you'd like to say before the court passes sentence? You have failed probation 4 technical times that I have right in front of me.
Yes, sir. Yeah.
And I know this isn't easy, but we're getting to a problem.
Yeah, like I said, the last thing is the treatment teller test. That's the only option, and that's the last option.
Well, it is the last option, but there's jail as an option too.
Yes, sir.
You know, I mean, it's supposed to be, I'm not naive to the process. I know that it's supposed to be harder for you to get it in any type of methamphetamine or amphetamine or alcohol in jail. It's supposed to be harder. I don't know if it is harder, but I can place you in jail, and I know for the next 6 months you won't be getting, or it'll be harder for you to get. Now, that may not cure your addiction, but at least I'm satisfied that the rest, this is a use, I believe. So it's on the on offer rejected. So it started as a CSC. So we're dealing with at least, it's an attempt 4th, 1 year. That's how much you have on your sentence is 1 year. Yeah, so I can put you up away. I mean, I can put you up away for 9 or 10 months. So that's my way of saying, look, probation is kind of a gift, and you got to work on your gift. And you've tested dirty on what we've given you. I can say at least twice. You violated probation in May 6th, and you violated probation again today on June 17th. So I'm kind of running out of options that with you. I don't know how much you bought into staying clean, and part of the option for staying clean is investing in yourself and saying, all right, I need to work. This is my time constraint. I don't know that you're doing this, and I'd like to give those resources to people who are ready for our help. District Court's supposed to help you out. I'm just not sure you're ready for that.
I am ready. I just got back on first shift, and that's helping me now. But I was on second shift, and that like 10 to 2 was not helping me out.
But I'm not worried about shifts anymore. Okay? I'm not worrying. I'm worrying about Mr. Phillips making good decisions 5 years from now.
Yeah.
Right now, you're on probation to me. So I mean, whether you keep your job or not is one thing. I don't know. But 5 years from now, you've got to make good decisions. And you have a destructive relationship with substance. I mean, you're testing poorly all the time. I mean, you violated your probation almost every time you've been tested since April 1st, and we're into June now.
Well, I'm going through with my kid.
Yeah, I understand it's problematic, but it's not like these problems are going to stop.
It's in my consultation with him, and even when I wasn't handling his violation last time we were here, he indicated he has a problem. Obviously, it's clear that drugs is a problem, and he needs the help. He really needs the help. He understands the next time around is probably not going to be what he's hoping it's going to be today. He understands that. I mean, Your Honor, if you want to suspend a jail sentence, he's aware going forward today, this is his last chance.
Right. But
and it's clear as day to him.
I think last time was his last chance for no jail. Okay. Mr. Phillips, you're going to do 5 days in the Ingham County Jail. Okay. And you're going to start today. We're going to take you right now, and you're going to do 5 days. You're going to so I'm ordering 5 days in the Ingham County Jail for your 4th violation. That's violation number 4. But it's a technical violation. I have number 4. 5 days in the Ingham County Jail.
May I ask, I see on the recommendation, weekend in jail held in abeyance, was that for the last violation?
That was for the last violation. That's not for the current violation. I am going to order that probations continue. You have a probation ending date of December 5th, 2025. You are in treatment for ABR Batters Invention. Continue testing at 3 times a month at AbraHealth. The last received results, I believe, were met. I'm continuing probation. I'm going to add an outpatient treatment to this that is requested by the probation officer. When you get out, you're going to be on SoberLink, Scram, Interlock for 60 days. So the interlock's going to be a part of this. So essentially, you're going to have a problem driving if you're not sober. Okay. I'm doing this as kind of the wake-up call. Okay. It's not next time's a wake-up call. This is a wake-up call. Okay. Because the next time you violate, I'm running out of options. I really am. Well, let's hope. I completely hope you prove me wrong. Okay. I completely hope. But that is the judgment for the probation violation. The second, at first 5 days in the Ingham County Jail, and then I'm going to follow the probation violation recommendation authored by Nathaniel Neves. You're all set for you, Mr. Phillips. Good luck to you.
I'm going to speak to him in the hallway for a moment.
Okay. I'm going to keep that one to do my notes on that.
I sent the condensed version of that.
Okay.
Emily.
That's Mr. Phillips. I think that's a 10. So I think it started out as 5. Then Mr.
So 2. He paid. The money letter was to Mrs. Smith, but his money that he was paying. And I'm gonna return. Huh? No. Was Joe? It's already supposed to be here.
He's here.
I can borrow that out of there until I don't just for everyone to the jail side on it.
On Phillips?
Yes.
Yeah, and then give it back.
I mean, give it right back. Yeah, I'm afraid I will forget that later and I'm not trying to do it.
So, Mr. Hardy, did you need Mr. Castillo brought up?
Yes.
All right. So let's see who is Mrs. L calls next, and then we can go get Mr. Castillo.
Check was in that check was stolen by his client. So then that money is now with the client. She didn't cash it, but she still had that check. So I have gotten no information. He hasn't gotten that money back. We have not gotten information that the person who wrote the check. He went and got the money order, got the check. Johnny East does not have that receipt for the money.
Mr. Harvey,
Yes.
you submitted a packet to
So you want to,
Kelly.
did you hear anyone tell the restitution?
Yeah, that was my mistake. There's miscommunication.
I don't.
It's not completed. There's no orders with it, so there's nothing for judge to sign. It's just the cover sheet and the petition. There's no order in this packet.
1 moment.
Well, I'm trying to preempt what I can. and Let Judge do what he's doing and Gabby do what she needs to do. And just trying to get a whole set together for us.
I think it's the ones that were cash. The ones that were cash.
Right, but he still out his money. That money was going to. Not going to the two, the other one, but sure. Honestly, I don't see your. It doesn't make sense to me because the money is there. Money is there. The rest of the time with the other ones. You know, this, so like, if you want me to prevent and you want me to have to do this restitution, then that's fine. I'm gonna have to adjourn today, get that restitution taken care of. I will have Mr. Disco testify to checks that taken from him, and how he knows who took the checks, where those checks went, how he knows it, and he can do that. That's fine. I don't care. So let's just put it on the record, but I'm not going to sit there and say that she's not responsible. Especially when we agree to the restitution.
I don't know if you'll need anything else for Phillips.
Yeah, that's my.
Should have my notes on Phillips to follow the recommendation. You got 5 days.
What are we doing?
Don't worry, I already sent it down. I sometimes just send Emily a very condensed version of what you write.
All right, so Mrs. L, who are we calling next? And we can send Megan down to get Castillo for Mr. Hardy.
I'm working with my paralegal too.
All right.
Attach the.
All right, so let us know. Let us know. Mrs. L, who did you want to call next?
I believe we're already on Deja Mitz. If I said that wrong, I
Miss
apologize.
Mitz, Deja Mitz. All right, and then Mr. Hardy will let Miss Slaviak know when to get Mr. Castillo.
Yeah, I'm hoping the order should be.
And then we also have Ayers Ellis is in lockup, Gonzalez is in lockup, and Mr. Ray's in lockup. So let's go on Mitz. And I have 2 files for Mitz. That's a sentencing and a PC from the UP. Is that right?
Correct,
Yes,
Your
Your
Honor. The felony case should be resolved today with the sentencing.
All right.
Yes, I
That was the-
represent Miss Milks on the misdemeanor sentencing, and then Miss Mitz, apologies, and Mr. Milks, apologies again, is here on the felony.
All right. All right, so let's do the sentencing first. So we're on the record in docket. And would you, that I should call the sentencing first or the prelim first? Sentencing first.
Yes, sentencing
Okay,
first.
all right. So we're on the record in docket. I want to make sure I get this right. 21-01767. That is people of the state of Michigan versus Deja Mitz. Will the parties please introduce themselves for the record? Mrs. Upton
Thank you, Your Honor. Gabrielle Lizelle, Assistant Prosecutor for the People.
and Mr. Harris.
Assistant Public Defender here, James Harris here on behalf of Miss Mitz, who is standing to my right, Your Honor.
All right, and then Mr. Milks, you're here on the probable cause sentencing that we've set in concerning the uttering and publishing felony on 24-02193. Is that correct?
That is correct, Your Honor. I'm also here because there's going to be an issue just regarding restitution that we're just going to need to place on the record here.
All right. And ma'am, you are Deja Mitz, is that correct? All right, thank you. All right, this is the time set for sentencing in the matter. I have a pink sheet for restitution, so we'll address that at. I have a pink sheet for $1,840, and then I see restitution here at $1,289.50. So there's some discrepancy between the pink sheet and restitution that's followed ordered by probation.
Well, good news, Your Honor, we've got even more discrepancy.
All right. Well, more recommendations means more variables. Mrs. L, there is some discrepancy between, before I let Mr. Harris, Mr. Metz make the case, What is going on in regards to restitution in the matter?
Your Honor, it's my understanding that the restitution is a combined restitution from both of the files. The restitution amount that was provided to probation services by our victim advocate only accounted for that misdemeanor file, and she went off of the police report number. I do believe she did not see the actual receipts that were in there. From my calculations, the number on the misdemeanor case would be the 1,840.
All right. And that involves both the misdemeanor file and the felony file.
No, Your Honor, that's just the misdemeanor file.
That's
The
just the
felony
misdemeanor
file, Your Honor, we have a bit of a calculation still happening there. I am trying my best to work that out.
Your Honor, if I can, and I'm not trying to step on toes.
Right.
We are agreeing to the $3,835 at this point. It's against my advice, but my client recognizes what happened here and she wants to make full amends. That's what she's coming to the table with. There were some arguments, and I apologize to Mrs. L because this was last minute. She has been working incredibly diligently, getting all my last minute questions together, but she's made a sound argument here. Again, I think there's an argument here. My client wants this done and over with, and we're agreeing to the 38. What did we say, 35? So 3,835.
That's on file 2402-193, correct?
Yes, Your Honor, and I
All
am
right.
writing a pink sheet for that as we speak.
All right, so just on the misdemeanor sentencing, which is file 2101-767, we've set it at 1,840. Is that correct?
I believe that's the amount, and when I add up the numbers in the two receipts, I think it's $1,839.50.
Okay.
I would agree with that, and I would trust Mr. Harry's calculations.
All
on
right, so
that.
it's 1,700.
Or 1,800.
$1,839.50. Okay. They're never going to be able to read this right. That's my key to you that we're probably going to print this out again.
Is that a total for the misdemeanor?
That's the total for the misdemeanor, $1,839.50, which is a 50-cent different than the pink sheet that was submitted. So we're right in that ballpark. All right. So Mr. Harris, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, I have gone over the pre-sentence report with my client, and she indicated, and we do not have any additions, deletions, or corrections.
The misdemeanor sheet does indicate from the probation office, Brendan Hanna, of the $1,289.50 that Mr. Harry spoke of. So that's the restitution in the pre-sentence as recommended.
Yes, Your Honor.
Which is the same amount.
Mr. Milks did point out to me, I guess there would be one correction for the PSI, which is that restitution is the $1,839.50, not the $1,289.50 listed in the PSI.
So we'll indicate that correction. So that correction is noted, or that difference is noted. All right. Anything else concerning any? So with that note, anything else towards the pre-sentence report, Mr. Harris?
No.
Yeah, yes, Your Honor. Because the felony case is being dismissed, I think we also have to include the amount that Ms. Ellis is going to bring up to you here with the restitution. I think we have to include it in this one since the felony case is going to be dismissed. That's my understanding.
That they would both go towards the misdemeanor file.
Correct, Your Honor.
Because the felony file would no longer exist.
Correct.
That makes sense. So we have $1,839.50 on the misdemeanor. Do you have a restitution on the felony file?
Yes, Your Honor. That's the $3,835.
Thank you, Mrs. All right, I'll put that, and I will also indicate that restitution is to be made on file. Now we're really good. They're really gonna have trouble reading my handwriting. 9-3, and that is $3,835. And do we have a victim on that? That's John Addis.
Yes, Your Honor.
Add this, all right. And then let me get a total amount for both. So $1,839.50 plus $3,835, which gives us a grand total on restitution of $5,674.50. Okay, so do I have both restitution amounts correct? And then I added them together for restitution on this misdemeanor, Mr. Harris.
Yes, Your Honor, I
That's-
agree with that, and I will defer to Mr. Milks regarding
All
his
right.
file.
I have $1,839.50 and 50 cents on the misdemeanor file. I have $3,835 on the felony file for $5,674.50. And Mr. Milks, you've indicated that your client is going to pay the $3,835 based on their indication of understanding the nature of the exam, nature of the restitution, but that is against your counsel's advice at this time.
It is against counsel's advice, but my client, again, wants to make sure amends are made and just take care of all her debts. So
All right. All right. Mrs. L, is that a correct amount? $5,674.50. That's the two files put together.
That is correct, Your Honor.
All right. Anything towards allocution, Mr. Harris?
Your Honor, Miss Mitz is in, and when I spoke with her, has indicated that at the time this seems like this may have been an issue of poor judgment at the time. She has since grown older, more mature and wiser, and realizes that she should not have acted the way she should have in regards to the misdemeanor file regarding damage to the complaining witness's windshield. She is ashamed and apologetic regarding her actions and wishes to make amends. That is why she is willing to participate in whatever terms of probation are being ordered or what probation finds necessary to resolve this case. That is also why she is trying to make amends and pay back what she believes is owed for her actions. I would recommend, Your Honor, that and request that the court follow the recommendation of probation and sentence her to the 8 months of probation with Zoom reporting. In terms of fines and costs on this case, there is a rather hefty amount of restitution, plus there will be probation oversight fees and any potential fees regarding any potential programming she might be required to take by probation. So I would request that the court delimit or otherwise waive what fines and costs they can to allow her to put the resources she has towards whatever programming probation is requiring, or the restitution. I would request, Your Honor, regarding the random PBTs. As to my knowledge, it did not seem to me like this was a case where there was concerns regarding substance abuse or whether substance abuse was a factor in this. So I would request that the court not order the random PBTs, as that would, in addition, also be another financial burden on my client that could make it difficult for her to more properly pay back her restitution, as she does currently have limited resources and has a lot of other payments in her life that she's trying to make. So, and beyond that, Your Honor, I would simply request that the court otherwise follow the recommendation, and I will leave it to Mr. Milks if he has any other statements he would like to make regarding sentencing, Your Honor.
All right, Mrs. L, do you have anything on the misdemeanor for sentencing concerning this matter? Mrs. L. So this would be on the MDOP.
Thank you, Your Honor. We would echo defense on the fines and costs. We do think a lot of the effort should be focused on repayment to these victims in these cases. This case has been dragged out for quite a period of time, both cases. And we would just ask that be taken into consideration. The rest we leave to your discretion. Thank
All
you.
right, thank you. Mr. Milks, did you want to be heard? I know there's the misdemeanor restitution that's part of the felony file. The felony has been indicated it's going to be dismissed. Did you want to have any, did you want to make an argument in regards on behalf of Ms. Smith on this sentencing, which involves some of the felony UP sentence, UP file?
I will, Your Honor, and I'll try to be as brief as I possibly can, knowing that's pretty difficult anyways. Your Honor, in this situation, Your Honor, I'm asking that the court consider only a reporting probation, letting her focus on making payments, as well as minimum fines and costs here. The misdemeanor itself was from well over 4 years ago. The forgery case was from January of last year. The reason this is important, Your Honor, is because she was going through the throes of addiction at that time. She had a heroin addiction, which is clearly listed here in the PSI. What is incredibly well, not impressive, Your Honor. What was motivating these crimes, Your Honor, was feeding that addiction. Now, because of that, she has been self-motivated. She got herself to Bear River. That was not under court order. That was by herself wanting to be clean, needing to be clean. She currently has family support in the area. So it's important to understand where she was at that time, where her mindset was, because this is several years ago.
So I have Bear River, November 2024.
Correct. The incident occurred several years ago.
That was a year ago.
Bear River was, yeah, correct. The court's correct, November. This incident itself was over a year ago. She has addressed many of these behaviors that the court would seem to rectify. She understands that when she was in these positions, Your Honor, and the reason she's not contesting some of the restitution here is because she made some decisions that she may not always remember things that she did, but has no reason to disbelieve the fact that she did wrong. She knows she did wrong. I think the next part of her recovery, Your Honor, is talk about in the 12-step program, is to make those special amends here. Restitution is that amend. She's already suffered herself, feeling terrible, not liking who she is, not liking what she did. I don't think there's much more regarding the snow factors that this court can truly address in that sense. Letting her, though, show this court, show the prosecutor's office that she wants to do right. I think this is the next step, Your Honor. So I would ask the court, and I'd actually ask if the court would consider 12 months of a non-reporting, or I'm sorry, like a Zoom reporting probation, Your Honor, to give her that extra time. She does have a job interview coming up. She was holding off just because it's very difficult to get a job with charges pending. But she's got a job lined up, or I'm sorry, interview lined up regarding Dave & Buster's. And she waitresses, she can do very well there. So I appreciate the court allowing me the opportunity. I appreciate Ms. Zell for putting up with me in these last minutes. I know I can be difficult, but I greatly appreciate it. I appreciate your honor. Thank you.
Thank you. Ms. Smith, is there anything you'd like to say to the court before the court passes the sentence?
I take full responsibility for my actions. My goal was to turn myself in, but that happened. But I'm happy to be here and just get this over with.
All right.
And yeah, get this all behind me.
Well, Ms. Smith, I have the same goal, but it's a little different from your attorney's goals. Okay. But one of the things, I'm very familiar with the 12-step program. One of the things that you have to make amends is that you have to, part of that program is learning to like yourself again. Okay. And making amends, and also making amends to the people who love you the most, who really are concerned about you and only you, and making amends to them too. That's one thing I believe in. Okay. I strongly believe in that. The other thing is that 5 years from now, Ms. Smith, you're a young person and you're still going to be around, and you got to make good decisions. And you have to decide if you're going to have a destructive relationship with any type of substance, or if you're going to have a productive relationship with any type of substance. I don't know, but I know that this is fairly destructive. Okay. The path that you were on is fairly destructive. You went in on November 24th. You got yourself to Bear River, and you're working on that. And it is a day-long struggle. It's every day. It's just vigilance. So I'm going to meet you halfway. All right. I'm going to meet you halfway. I agree with Mr. Harris and Mr. Milks that you have an enormous restitution concerning some of the things that happened in the past. And so we're going to work on that first. I do think that you have to be responsible. And also, if you have chosen this path of sobriety to work on, then part of this probation should not be a problem, okay? If it becomes a problem, then I know we've got to offer more services and we got to do everything to help, because I want you making good decisions 5 years from now. I mean, this is a pivotal moment for everyone involved. And I think that's important. You either adopted it or you haven't. If you haven't, we still need to work on it, okay? We don't shun you. We don't do anything. We just work, all right? Everybody has to work for you. But if you have adopted, that says a lot about you, okay? So I will, for the guilty verdict of 2000, found on February 18th, 2025, I find the defense pled guilty, the MDOP $200 to $1,000. I'm going to order that the defendant spend 1 day in jail with credit for 1 day previously served. I will suspend 60 days upon successful completion of probation. I'm going to, this is where we're going to look to help you, okay? I'm going to waive fines and costs. I'm going to waive the crime victims' rights fee and the state minimum court cost fee. This will be abstracted as a misdemeanor, but then you can put all your resources on yourself and those that need restitution, okay? So restitution is to be made to Maria Sklapski for the MDOP $200 to $1,000 in the amount of $1,839.50. And then $3,835 is to be made to John Addis concerning the uttering and publishing file of 24029193. Probation is for 8 months. Okay, it's 8 months probation. So all the restitution goes at the end of probation, but you can start immediately. It's up to you, okay? But that total restitution is $5,674.50. There will be also a no contact order with Mr. Addis, other than peaceful contact and providing some type of restitution. But this has to do with the MDOP $200 to $1,000. So there'll be no contact with victim Maria Sklapski within 2,000 feet of where the victim lives, works, goes to school without consent of this court. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, controlled substance without a prescription while you're on probation. And that's usually what catches people. They come in, they drop dirty, or they fail their drops, and then we have to start dealing with technical violations. And we already know there's a problem, okay? And you're working on the problem. There's no shame in that, okay? There's no shame in that problem. It's just the way it is, okay? And then we work from there. No, submit to random PBTs and your analysis as directed by your probation officer. It's your chance to show off, okay? That's how I would look at it. I think no bars or nightclubs for the amount of duration is a good idea, okay? Unless you're working there. If you are working there, because I know like at Dave & Buster's, they serve alcohol. So unless you're working there, and you can work with that with your probation officer that way. He'll work with you on that. Because that's not their main source of income, although it's an important source of income, I would think. Outpatient substance abuse within the parameters of your probation officer is ordered, so he has that. The anger management group, I'm going to wait till you can finish off with that. That's the last weekend. That can be a part of probation. I'm going to make that a part of the order, but I'll leave it up to the probation officer. That's not as important as some of the substance abuse recommendations that he's made. Obtain and maintain employment. You're already working on that. Not purchase or possess firearms, ammunitions, or weapons of any kind. That goes to every probationer. Ms. Mitz, do you have any questions concerning the judgment of sentence that I've laid down? All right. All right. I'm going to sign this, and then we're going to make all of this look pretty, because it does not right now. And I will indicate that to see GOS, and then we have the second UNP file. All right. This will go, so the JOS will go in the misdemeanor file. So we're set on the misdemeanor sentencing. And then Ms. Azell, did you want to be, oh, this is the JOS that is supposed to be nice and neat. All right, and then Ms. Azell, did you want to be heard on the felony UNP file of 2402193?
Yes, Your Honor.
You may proceed. Appearances for the record on that file. Mrs. L, I'm Mr. Harris. I don't know if you're in on that sentencing. I know Mr. Milks is.
I'm not, Your Honor.
All right, Mr. Milks. Appearances for the record.
Gabrielle is also the prosecutor for the people.
We've probably already done this, but we're double checking.
Good afternoon, Stephen Milks on behalf of my client's business, defense, thank you.
And Ms. Mitz, you are here, Deja Mitz, on this file 2402193. Is that correct?
Yes.
All right. Mrs. L, how are we proceeding on this, on the felony file?
Your Honor, at this time, the people would move to dismiss this case for agreement in the other file. Thank you.
And I'm assuming there's no objection to that, Mr. Milks.
Okay, no objection.
And you've made your, the objection was noted on the previous sentencing. So I will provide a nollie pros to Ms. Azell to do on the felony file, I would think. All right. So that 2402193 will be dismissed without prejudice on pursuant to negotiations and the last file sentencing on the last misdemeanor file. What without prejudice means, Ms. Mitz, is the people could reissue if they choose to. Realistically, they can't because it's a part of the other agreement. But that's a default for dismissal without prejudice. And this case is dismissed for global resolution. I will sign this order on today's date, June 17, 2025. Anything else for the record in 2402193, Mrs. L?
Not for the people.
Mr. Milks?
No, thank you, sir.
Okay. Ms. Mitz, good luck to you. We're all set.
She should go to probation right now. She get down there.
She can check just to see, I think it's Bayless. I think it's just to make sure you're on the same page with that. Where did you want to go next, Mrs. L?
If we could go to the Paris Mendenhall case.
Harrison Mendenhall. All right, so we're on the record in docket 2403511. That is People of the State of Michigan versus Paris Mendenhall. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Mendenhall for the probation violation. She's standing to my right, Your Honor.
All right, and ma'am, you are Paris Rashonda Mendenhall, is that correct?
Yes, Your Honor.
Thank you. This is time set for a probation violation hearing. Mrs. L, how are we proceeding, or would you like to defer to Mr. Harris?
If I could please defer to Mr. Harris.
Mr. Harris.
Your Honor, I've spoken with Ms. Mendenhall regarding the violations. I believe there's 2 violations from the May 20th request and summons for probation violation. And then 1 violation, and then
I have May 20th, 2 violations on, I have violation 13 and 16 on May 20th, and 13 and 13 on May 20th.
yes.
So I have 4 violations.
Yes, my client is going to be pleading to the violations with an explanation, Your Honor.
All right. All right, thank you. May I inquire of Ms. Mendenhall of her understanding her rights in this file?
Yes, Your Honor.
Ms. Mendenhall, you understand you have a right to a hearing in the file. You have the right to be represented by counsel. You're represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Would you understand that, ma'am?
Yes, Your Honor.
It's my understanding it is your wish to admit to the allegations with explanation, and then we will proceed to sentence. Is that your understanding, ma'am?
Yes, Your Honor.
All right. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
I'm going to take you back to probation hearing. So these are not the amount of probation violations. These are just listed so we can differentiate It is alleged that on or about April 24th at Aberell, that you tested positive for what's known as buprenorphine, buprenorphine, buprenorphine. Do you admit to being positive for buprenorphine on April 24th, 2025 at Aberell?
Yes.
Okay.
Apologies, Your Honor. I forgot to mention regarding the THC marijuana positives, my client did indicate that she has a valid medical marijuana card that was valid as of 4/17 that she indicated she provided to probation. My understanding is, I don't exactly know why it has not been.
Does buprenorphine have THC?
And no, I believe it indicates that on the 4/24 and 4/30 tests, it was positive for an amount of buprenorphine and THC.
All right, I'm assuming the THC is, the positive for buprenorphine is enough in itself, so.
Yes.
Okay, all right, so I'm not even covering the THC that they found. All right, in violation 13, which is, and I'm glad Mr. Harry's pronounced it, buprenorphine. You tested positive on April 30th, 2025 for buprenorphine. Is that correct, ma'am?
Yes, Your Honor.
All right. Allegation on 4/24 and 4/30. All right, and then on May 7th, you tested positive for alcohol and cocaine and buprenorphine on May 7th per AberHealth. Do you admit to all those allegations?
Yes.
Okay. May 7th, admit alcohol. And cocaine. And then on April 15th, this has the allegation is that you were unsuccessfully discharged from IOP intensive outpatient on April 15th. Were you unsuccessfully discharged from IOP on April 15th, ma'am?
Yes, but that's explained.
Okay. And then you can explain. All right, so I have admitting to April 24th, April 30th, May 7th, and April 15th. And then you can make your explanation as part of the allocution concerning the sentence. So I'll go to Mr. Harry's first, and then I'll hear from Ms. Mendenhall.
Yes, Your Honor. When I spoke with Ms. Mendenhall, she indicates that she has been dealing with a lot of stressors and dealing with a lot of medical issues recently. My understanding from her is that she's currently working with her primary care physician to get a Vivitrol shot for some medical issues she has, and that apparently there was a bit of a delay in when she was supposed to be getting started on that, and as a result, she unfortunately ended up turning to another backup for dealing with that issue while she was waiting on the Vivitrol shot, which ended up being the buprenorphine. She understands that was a mistake, and that is something that she would not be allowed to be on with the random testing, and that is why she is working with her primary care physician to try and get the Vivitrol shot set up as quickly as possible, so this issue will not happen again. Furthermore, as I indicated, Your Honor, the marijuana she has a valid card for, so that should be resolved. Then
you've not addressed the alcohol and cocaine.
And yes, Unfortunately, Your Honor, she indicated that those were a moment of weakness, a moment of her giving into her stresses. She realizes that the intensive outpatient is something that can help her deal with proper, more healthy ways of dealing with the stressors and the issues in her life. She did indicate that after she was told she had been unsuccessfully discharged, she contacted the provider for the IOP to resolve the reason why she had failed to appear, and has since gotten back into IOP and has good attendance since. My understanding is the IOP treatment center did send records of her attendance to that since to the probation officer. I don't know if that was included in the paperwork I received or the paperwork the court has, but that is what my client has indicated to me. As such, I believe Ms. Mendenhall can benefit from remaining on probation and being allowed to participate in the intensive IOP to learn more healthier, constructive ways of dealing with her stressors and dealing with her substance abuse issues. So I would be requesting that the court to follow the recommendation regarding the recommendation of IOP of re-engaging with intensive outpatient procedures within 30 days. My client has already indicates she has already done so. Regarding the recommended once per week urinalysis testing, my client is willing to agree to that. However, I would be requesting if the court would consider ordering that for 60 to 90 days and depending on her test results, possibly returning to the original testing schedule as once per week testing. My client has indicated would be a rather significant financial burden for her. Finally, regarding the 4 days held in abeyance.
That should be the center of your argument, because
Yes.
I'm wondering if that should not be held in abeyance right now.
Your Honor, Ms. Mendenhall has indicated that she realizes she had a stumble. She realizes she made a bad choice, made a mistake while she was on probation. She is trying to make up for that mistake. She's not trying to run from it. She is not trying to avoid responsibility or claim that didn't happen. She is owning up and taking responsibility for her error. She has since gotten re-engaged with IOP, which she indicates is very good for her and very healthy. It helps her, like I stated, Your Honor, is helping her develop in more healthy and more constructive ways to deal with the stressors in her life and to deal with her issues regarding substances. It's also giving her a lot of support for the times where she feels like she might have otherwise turned to substances. At this point, I believe any kind of jail sentence could potentially compromise her ability to properly participate in that programming and properly engage in that support that can help her with her substance abuse issues, Your Honor. So I would be recommending that the court do hold that in abeyance and not order my client to serve any jail time today. And that is what I would be requesting, Your Honor. Thank you.
Thank you. Mrs. Zell, towards the judgment of sentence, and then I'll go to Ms. Mendenhall.
Thank you, Your Honor. Just briefly, we are a little bit concerned based on the probation officer's indication that the substance use appears to be getting worse. On a term of probation, we expect to see that substance use getting a little bit better. We do have concerns with the amount of violations as well. Since this isn't just one little stumble, we are concerned there. At this time, Your Honor, we would ask that the recommendation be followed. Thank you.
Thank you. Ms. Mendenhall, is there anything you'd like to say to the court before the court passes sentence?
Yes, Your Honor. First, give glory to God who's in my life. But when I caught that drop for Mr. Flores, I was under so much pressure and trying to do more than I could do myself. And I lost that battle. But since then, yes, I do have cravings, but I've been talking to my therapist, Ms. Dawn, which I have been going to my IOP, my probation officer, who is Joe Sumner. I don't know what's going on.
He had a baby.
Oh,
He had a
I've been
baby
turning
about
all my paperwork.
30 days to, yeah. So what happened with Ms. Bayless today?
Well,
Because I know security was called
yeah,
and it did not end well.
I was trying to explain to her, which is not right. I deeply apologize. But when she told me that I needed to be in a intensive inpatient, it kind of triggered me because, Your Honor, I was incarcerated and did not join no MAT program. I did it all on my own. I came home, stayed clean until I hit that bump. And I didn't go to no street drug. I went to pieces of Suboxone and that's it. That's what the B word is. And I brought it up to my therapist, Ms. Dawn, and we're in the process, because I don't want to be on that. That's just another form of addiction. So we're in the process of getting me on the Vivitrol shot.
You know, this all stems from a guilty plea to use of cocaine. Yeah, I'm more worried about you 4 years from now. I've said it before. We're here to help, okay? District court's not always the most helpful court, but we have resources. And we need for you to take advantage of the resources because you got to make just good decisions 2 or 3 years from now. And there are people here trying to help you, and your default seems to find a fight. Okay, regardless, you want to fight those people. And I don't want that to happen because I don't want them not to like you because you seem like a very likable person. But I also don't want you to think that they're not trying to help you because they are trying to help you. And I'm running out of options. That's my fear. As we start running out of options, you start testing dirty, and then I run out of options. And then I know that I've got jail as an option, and I know it should be harder to get drugs and alcohol in jail. It should be harder. I'm not naive to the practice of drugs and alcohol being in jail, but it should be harder. That's my last resort. Okay, that's my last resort. But here's the problem. You've got to be willing to accept the help. You've got to be willing to address it, to show off a little bit, and to say we're working with you. And that's my concern. My concern is I don't want to kick this can down the road. I don't want to see this because I've seen it too often at this point. I've just seen it too often. There doesn't seem to be this need to help. Let us help you. Okay.
Yeah,
Sure.
My therapy has been doing great. You know, I'm not even kidding you. And I literally just got a job at McDonald's, literally yesterday.
Right.
And I was supposed to be at orientation today at 4:00. And my husband said my living situation was so hard with my kids. I found a better place. I'm actually supposed to be getting engaged. And I don't want to ruin my life. I don't want to be on Suboxone. I don't know what's taking us so long with the Vivitrol, but like I told my attorney, I'm going to have my sister who supports me. She's in the courtroom. She's my biggest support system to take me there, to bring you guys receipts and to show that everything that you gave me, the chance you gave me is working. Yes, I slipped up. I understand I slipped up, Judge Flores, and you told me.
Well, I worry about that. I worry about that. The recommendation. So if this isn't working, I need for you to tell me how to work this. And you're telling me I can do this.
Yes, sir.
And to hold it in abeyance. And that's a recommendation. I'm going to follow the recommendation. Okay. I'm going to follow it. But we can't have any more of this. You meet with Miss Bayless and security gets called and you're angry at Miss Bayless and you're angry at Joe Sumter. Joe Sumter's taking care of his newborn. He's out on FMLA and it becomes a problem. And we can't have any more of that, any type of more. And I do think that's a result of being under stress, pressure, some part of the anger management, and that might be something else going on. I'm not sure. Okay, there could be some self-medication at this point going on. I don't know because I don't have enough letters after my name to know. What I do know is that if there's another violation, that 4 days held in abeyance is just 4 days. It'll be whatever the sentence is, and you're already doing the 4 days. Okay, I'm going to hold it in abeyance. For me, it's already been scheduled. But I'm willing to work with you here. Okay, but you have to work. You got to help. You got to let people help you. Right. I'm willing to help you. You understand the parameters. You understand the importance of dropping dirt. It happens, it happens. And then I'd say 80% of when I see people come in here and drop dirty, my understanding is they're working on a problem. It's you know, if you can't stay clean 6 months after you're sentenced on a misdemeanor file, when you know everything's at stake and you know that you're being tested and you're still testing dirty, we got a problem, okay? So I'm gonna follow the recommendation. So I'll follow the recommendation of the probation violation recommendation. So it would be testing at AverHealth 2 times. They have the date last tested in May 7th. From now on, it's 2 times a month at the request of probation. There's a current balance of $985. The probation ends on February 13th, 2026. We're going to continue on probation per the recommendation. I'm gonna hold the 4 days in abeyance. That'll be held in abeyance. I'm going to add the IOP within 30 days of treatment, as we discussed, and then the 1 time per week of urinalysis testing. Just that's your chance to show off. All right. If you come back and we see that it's not working, then we're starting to run out of options. And I can say, Ms. Mendenhall, you need to help. Let us help you. Okay. If that's the case, there's no shame in doing it on your own. Perfect. But if you need assistance, let us help you. Okay. We're take advantage of this. Okay. This time you have till February 26th. I'm going to mark today's date as June 17th for this violation. So I would expect that after June 17th, it's clean. It's clean and clear running to February. If it's not, we understand this may be bigger than all of us. And then we got to work at it. All right.
More question.
Sure.
What about the THC? That's it.
As long as you have a medical marijuana card, I'm going to treat it as a pharmaceutical. Okay. That's been prescribed to deal with. But this is a big but. You can't depend on that to help you get through this. That card is not going to help you get through this, because 2 years from now, you've got to make good decisions, and that card could get you in somewhat trouble. Okay. You know that, and I know that. So you know you've got to make good decisions, and we're working on that now. Right. That's part of this. So I would go down, I would call in and see who you're doing. I think Mr. Sumter's probably got 2 weeks left on his schedule because he's on FMLA with his newborn. But check in who you're supposed to see with, call in, check in who you're supposed to see with, and then wait for Mr. Sumter. We have 4 days in abeyance. Ms. Mendenhall, do you have any questions concerning the judgment of sentence on the probation violation? All right. All right. This works. How this really works is we see less of each other. Okay. Where you're not into my stuff, I'm not into your stuff, and it's all good, right?
Yes, ma'am.
All right. If this doesn't turn out that way, let's see if we can find a way to fix it. All right. All right. You're all set, Ms. Mendenhall. Thank you.
Thank you.
Where did you want to go next, Mrs. O?
That's a great question. I believe we have a couple more people who are here in person already.
All right. We have 4 in custody still, and then I have plenty other stuff. The civil stuff that we're ready. Mr. Hardy.
We've been able to submit the order with the confidential petition to Wendy. So we should be ready to go, Mr. Castillo.
So you want to bring Castillo up? All right. So Megan, bring up Castillo.
I believe that's a private case as well. So we would need to
All right. That's a 769-4A case, and I've told a 769-4A is not a private case under the court rules. Have you heard differently? I got a note from the chief judge indicating 769-4A is open. It's an open case to the public and cited the court rules, unless it's under one of the under the parameters. It doesn't matter to me. I'm just indicating what the chief judge said.
Okay. Ultimately, it doesn't matter.
All right. On that case, since it's going to be Let's bring it up because I know that's a sensitive case. Is there anything else, Mrs. L, that we can call before that?
I believe there are a few people who are out of custody who are here.
All right. So while Megan's getting Mr. Castillo, let's go on.
Sierra Porter Miller.
Sierra Porter Miller. All right. So is Sierra Porter Miller going to be a hearing or is that going to be a plea?
Plea.
All right. All right, so we're on the record in docket 24-03570. That is People of the State of Michigan versus Sierra Porter Miller. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Gonzalez, Assistant Prosecutor for the people.
Mr. Annette.
George, and back my APD, back my client is saying to my right.
And ma'am, you are Sierra Porter Miller, is that correct?
Yes.
All right, thank you. This was the time set for a probation violation hearing. It was on violations set up by Mr. Hanna. I believe that's on May 13th. Several violations. Mr. Ned, how are we proceeding today? Or Mrs. L, how are we proceeding? Would you like to defer to Mr. Ned?
I would like to defer to Mr. Ned.
All right, thank you, Mr. Ned.
Yeah, my client is admitting responsibility for testing positive for cocaine at EverHealth. I think it's 3 violations.
I have violation 13. And that one was on an April 26th date, a July 15th date, and then May 9th and May 13th dates.
Yes, Your Honor. We are with explanation on a few.
All right.
We are admitting responsibility.
All right. May I inquire of Ms. Porter Miller of her rights in this file?
Yes, Your Honor.
All right, Ms. Porter Miller, you understand you have a right to hearing in this matter. You are represented today by Attorney Georges and Ned, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes.
My understanding is your wish to plead that you technically violated your probation, and then we will allocate towards sentencing. Is it your wish today to admit to being on technical probation of your violation, Ms. Porter Miller? All right. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I'm going to bring your attention back to April 26th. It's listed as violation 13, but that's only to differentiate it. So I'll use the dates. That you tested positive for cocaine at EverHealth on April 26, 2025. Do you admit to testing positive for cocaine at EverHealth on April 26, 2025?
Yes.
Okay. All right. And that you failed to appear for intensive outpatient substance abuse counseling appointments at Mid-Michigan Recovery Services on May 9th and May 13th. Did you fail to appear for intensive outpatient?
Yes.
Okay. All right, those are the 3 because the one is indicating the amended order for July 15th. Those are the 3 technical probation violations that I see, Mr. Ned. Do you see any more?
That I see on the, I only have that one page general with the 3 that we just mentioned.
All right. All right, allocution, Mr. Ned.
And we're asking for probation to be continued and extended. Ms. Porter Miller needs help. This is obviously this case started as an OWI, and there's other, as we see now, it's cocaine and she is now signed up and attending classes. I think she said she has missed a few, but she's back on track. To my understanding, in regards to speaking to her, there's been a lot going on that she wishes to tell you about, Your Honor. Family, and actually Ms. Azell, the prosecutor, informed me some information today. It makes me even more inclined to ask for extension of probation and hopefully no jail, Your Honor. There's a lot of family issues and dynamics, mental health concerns. Really, a lot of bad things going on. At the same time, she's doing probation and trying to do the best she can. She's been on probation, I believe, for a little over a year now. She has no objection to the extension for however long the court believes is necessary. She wants to continue. She wants to stay out of jail. She wants to get the help she needs. She does have one child.
Yes.
She has one minor child that the prosecutor actually mentioned to you about here in a moment. My understanding that the drugs and alcohol is, or at least drugs is a problem at this time. Her mother is here for support today, Your Honor. We just beg for mercy and absolutely one last chance with a suspended jail sentence or whatever the court wishes to impose. She has no objection to any tether, any requirement, anything that needs to be done to prevent her from going to jail today or at all. She wants to prove the court wrong. There's been a lot of bumps in the road that she wishes to explain.
Mr. Judge DeLuca ordered 10 days suspended last time. But so he's suspended upon successful completion of probation. That was 10 days. Is that my reading his sentence correctly? 10 days suspended?
I don't know. I was here last time.
All right. Mrs. L.
Thank you, Your Honor. First, I would like to say I do believe that your reading of Judge DeLuca's note is proper there. Your Honor, it has come to our attention that around the same time as Miss Sierra Porter Miller's positive test, that her young minor child was showing some aggression towards animals within their home. This was brought to the attention of our office due to the extremity of the injuries to the animal. And we do want to bring that to the court's attention, mainly because we do see now that the drugs are affecting Miss Porter Miller's home life. They're affecting her family. We would like you to take that into consideration. Thank you.
Thank you. Ms. Porter Miller, is there anything you'd like to say to the court before the court passes sentence?
Yes, I've been basically trying to stay afloat. I've recently started going back to my classes. So far as at Michigan, it was about the schedule I'm working in, going in, taking GED classes. So a lot of me missing classes, it was documented that I would call in and tell them that I wasn't going to be able to attend my classes. Also, my psychiatrist's office just vanished. So I was out my medication for a while. I've just recently got back in contact with my primary care physician. I've got some recent evaluations that I just did on different mental health situations. My medicine is back up and going. I'm just trying to stay afloat. It's me and my 4-year-old.
And Your Honor,
so far as getting a babysitter, sometimes that's a struggle. My mom is also trying to work to help me. So, I mean, I'm trying. I just got off tether June 3rd. I can go back untethered. Like I'm trying. I had some hiccups.
You know, she also mentioned to me that mental health is a concern. And if the court is going to impose some kind of sentence today, if there's any potential that she can instead go to some kind of mental health facility and obtain help.
All right, thank you. Well, you admitted on probation violations on July 15th, on October 10th, on January 28th of this year, and then today on June 17th. This case started, first arraignment was December 14th of 2023. So we've been going on this for a while. Probation is not for everybody, okay? And I certainly, Ms. Porter Miller, don't think it's for you now. I really don't think probation is the way for you to go. I think you probably, for whatever, it just hasn't worked out for you, all right? So I'm going to follow the recommendations concerning this. I'm going to terminate probation. I'm going to sentence the defendant to 40 days, 40 days jail. And we'll refer any collections, the $1,784 that I have is referred to collections. This is in no way giving up on you, ma'am. It's just probation. It's been 2 years and it's not working. Let's try to find something that works. All right, ma'am? All right. So 40 days in jail. based on the drunk driving. This started out as a drunk driving case. You're all set. Thank you for your appearance.
All right, and then you're not open to any mental health or weekends or anything like that?
Nothing, the 40 days and we'll get it over with. All right, we're all set.
Yeah.
Is Mr. Castillo with us? All right. All right. This was a YTA, I believe. Yeah, it was a 769-4A. All right, so we're on the record in docket 22-02201. It is set for probation violation hearing. Mrs. L, your appearance for the record.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Hardy.
Assistant Public Defender Joseph Hardy on behalf of Ms. Castillo, who is standing to.
And first of all, you are Alexander Castillo, is that correct?
That's correct.
All right, and then you prefer to go by the pronoun of they or them, is that correct?
That's correct.
All right, thank you. All right, this is the time set for a probation violation hearing. We adjourned it from last week to make sure everybody was here and everybody was represented. Mrs. Zell, how are we proceeding, or would you like to defer to Mr. Hardy?
Your Honor, if I could just make a brief record of
Sure.
my understanding, the last time we were here, we were discussing competency review for a probation violation hearing. I went back to my respective office and was told that we are concerned about that and do wish to have that mental health screening. I would now defer to Mr. Hardy to give more of a record. Thank you.
Mr. Hardy.
Thank you, Your Honor. Yeah, so I believe the case of People v. Martin, the citation 61 Mich.102.
Let me let me write that down because I may need to refer to that at another concerning this. I'll remember this file and then I'll come back and look at it.
Absolutely.
So state that citation for the record.
Yeah. 61 Mich.app 102.
102. Okay. Thank you. You may proceed, Mr. Hart.
So that case, I believe, can be determinative here in that probation revocation proceeding, something that a competency petition would be appropriate in, because if Ms. Castillo were to either plea or to be found guilty, then a jail sentence would be a possibility, and I would say, a likelihood as well. And due to this potential loss of liberty, we do think that a petition for a competency, is appropriate in this matter. We have filed that with the court today, and petition and the order for evaluation for competency with the Center for Forensic Psychiatry. So we would just ask, that order be signed today, just so Ms. Castillo here can be seen by a psychiatrist to evaluate some of the claims that we have witnessed.
All right, thank you. I don't know the case law, but it certainly falls in line that after a brief, we lost track of Ms. Castillo, and then we lost track of, and they came to us as an absconding. It certainly falls in line that we would treat this as a hearing. It does affect individual liberty concerning the recommendation is for credit for time served, essentially. So I'm in line with it. It seems the prosecutor's office is also in line with treating that examination in that way. I'm not going to modify bond for various reasons. So this is remanded under the course of, so we're going to have to keep track of the file. And so what we'll do is we'll set it every 30 days or 60 days for control day to make sure what's happening needs to happen. Okay. And if it doesn't, then we'll do something about it. What we've done in the past is we've show cause the Forensic Center for not filing a report. Okay, that's what we've done in the past. Usually when we do that, a report gets filed pretty quickly. Okay, usually within a couple of weeks. We've done that in the past. I don't think we'll need to do that on this occasion. but I'm willing to do it just because we've had some trouble in the past. I will sign the order for competency and then let the jail make arraignments. 6/19/2025. So the defendant is remanded for the competency review. Once the report's done, we'll have another hearing and we'll decide how we go from there.
All right.
And let's set this for a control date hearing so we don't lose track of it. So. I did have the opportunity to speak to probation. They said they were going to look into this also. I haven't heard back from them, but with both litigants and myself determining that this is the way to go here, I think that belt and suspenders approach is a better approach for us right now. So I signed the competency and we'll set a control date for review and report.
Would it be okay? Excuse me, I did 30 days so that I can make sure he gets an appointment.
Yeah, and then make sure it also works with Mr. Hardy's schedule, because I know you're on a different schedule with Judge Buchanan.
Yeah, looking at a month out, I know that I have a likely 2-day trial on July 28th, but July 21st.
All right.
I believe.
So July 20, how's that Monday,
I'm sorry.
July 21st?
I'm sorry, July 22nd.
July 22nd. That's a statute date for us, I think. Okay.
Yep, we want to do it in the morning or the afternoon?
Morning or afternoon, Mr. Hardy?
Afternoon.
So July 22nd, we can 1:30 too? 1:30. I know where Mrs. L will be here. And all right, so we'll set it for July 22nd at 1:30. Mr. Castillo, Miss Castillo, understand we're just waiting for the report now. Okay, so you'll at the petition, and I've signed the order. We're just waiting for the report. Hopefully you'll be seen within 30 days. If not, we'll see if we can nudge them a little bit. All right.
Great.
All right. Anything else for the record in 22-02201, Mrs. L?
Not for the people.
Mr. Hardy.
Nope.
Okay, you're all set, Mr. Castillo. Thank you.
Thank you so much.
Thanks. All right, and
Oh, Megan's not here. She
Doesn't talk. It's how-
okay, what's the
We have
time?
those here and ready to go. I believe we're ready on Dakari Richardson when you are.
We'll figure that out.
Okay,
Yeah.
2 days, but then whenever he would indicate.
And I posted that I signed the order on today's date. So technically he can get crime. It's within that description.
Okay.
All right. Let's go on. Did you say Ayers Ellis?
No, Dakari Richardson, please.
All right. All right, so we're on the record in docket 22-03062. That's not right. 24-03303. That is People of the State of Michigan versus Dakari Richardson. Will the parties please introduce themselves for the record? Mrs. Allen.
Thank you, Your Honor. Gabrielle Lizal, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Richardson for the probation violation hearing, Your Honor. He is standing to my right.
All right, and sir, you are Dakari Richardson, is that correct? All right, thank you. All right, this is the time set for probation violation hearing. Mrs. L, how are we proceeding, or would you like to defer to Mr. Harris?
If I could please defer to Mr. Harris.
Mr. Harris.
Yes, Your Honor, I spoke with Mr. Richardson regarding the violations and the options today. He indicated he is going to be pleading guilty to the violations, or pleading guilty to violation number 14 and pleading guilty to violation number 15 with an explanation regarding the missed tests, Your Honor.
All right. All right. So may I inquire of your client of his rights in this file, Mr. Harris?
Yes, Your Honor.
All right, Mr. Richardson, you understand you have a right to hearing today. You have a right to be represented by counsel. Mr. Harris is here and he's your attorney and he is here to represent you. He can cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish to plead to the technical probation violation, violations 14 and 15, and have this case continue to be sentenced by the court. Is it your wish today to admit to the probation violations indicated by your attorney? Yes, Your Honor. Okay, I'm going to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. I'm going to bring your attention back, and these are listed as a violation, the number, but that doesn't mean the number of violations. I think that's how they differentiate it. I will do it by date. So I think that's more concise. So it is alleged that you failed to refrain from alcohol and marijuana per AverHealth on April 4th, 2025, that you tested positive. Did you test positive for alcohol and marijuana on April 4th, 2025? Okay. All right. And in violation 15, did you fail to test and with explanation on April 7th, April 21st, May 2nd, and May 8th per AverHealth? All right. All right. So the admission to the probation violation has been knowing, voluntarily, fairly, and accurately made. And Mr. Harris, would you like to be heard on allocution? And then you can make any explanation or save that for Mr. Richardson concerning violation 15.
Yes, Your Honor. Considering violation 15, Mr. Richardson indicated that when he was getting the tests set up with AverHealth, there was a bit of confusion regarding whether he needed to call them or they were going to be calling him. Further, he indicated there was also likely the bigger issue, and the bigger part of it was some financial burdens and making it difficult for him to afford the cost of a test. That financial burden and those financial issues have since gone away. When I spoke with Mr. Richardson regarding this, he indicates that since the 5-8 test that he had missed, he has resolved all the misunderstandings. He gets notifications for his tests. He has been present for every test. He has been, and not only has he been present, he has been negative for every test that he has gotten since, which by my count should be about 5, almost 6 tests now, which would mean that he would have, if we were to balance out, he would now have attended and been negative on more tests than he had originally missed. I realize that's not an excuse or a reason why he shouldn't be punished. However, he indicates that it was a misunderstanding, a rather small mistake. I will indicate that in my experience, it seems it's rather rare that people make it through probation without some sort of stumble or some sort of issue. It seems like he had his stumble at the start and has since resolved it and has not had any issues since. He has indicated he's doing well now, that he does not believe and he will have any further violations. So as such, I would request, if possible, for the court to, rather than following the recommendation of the minimally suggested weekend in jail, the court possibly consider holding either that weekend in jail or possibly potential outpatient suspended upon any further violations, and essentially consider today to be more of a verbal warning, given that in this situation, it honestly seems, Your Honor, that the issues that probation was likely concerned about with the violations seem to have worked themselves out. He has not had a positive test since 5-8. He has not missed a test since 5/8. He's got a test later this week that he is aware of. Well, not later this week. Have you tested this week, sir?
Yesterday.
Apologies, sir. He has tested yesterday, so that would be 6 tests actually he has taken since. So from my understanding, it seems like he's already resolved and fixed the issues probation would likely be concerned about in this case on his own, and is now back on track to properly follow all terms of his probation. So I would be requesting that the court consider either a verbal warning or perhaps holding potential outpatient substance abuse treatment in abeyance pending any future violations. And thank you, Your Honor.
All right, thank you, Mr. Harris. Mrs. L, anything you'd like to say to the court before the court passes the sentence?
No, Your Honor, we leave it to your discretion.
All right, Mr. Richardson, is there anything you'd like to say to the court before the court passes the sentence?
Yes, Your Honor. I wasn't aware that I was supposed to call them a PO. Probably did go with me, but I went over my head. I'm sorry about that. But like he said, I made it back up. I talked to her. She told me I've been on a smooth line. I've been good. Just a little hiccup in the beginning, and I don't plan on disappointing.
And my understanding is probation is ending on September 25th. Is that correct? If probation stays the same? Is that a fair statement?
Yes, Your Honor, that's what was indicated in the paperwork I received.
All right, I don't have any probation violation. This is the first one. And so we're gonna follow the recommendation, and then we're gonna tweak it a little bit. So I'm following the probation violation recommendation. For the first technical violation, which were the admissions were today, I'm gonna treat it as a regular technical violation. So it'll be 4 days, but they're held in abeyance, okay? So 4 days are held in abeyance. And if you're able to complete probation in September, then we'll do away with those, all right? If we have another probation violation, that those have been ordered already, those 4 days.
Jody Bayless just said to us in this case, it says he did not test yesterday, he's still testing positive.
But that's not he's already admitted to the allegations.
Okay.
So if your probation officer indicates that you did not test yesterday, so that might be a part of allegations. I don't know. Like you figured out with their probation, but that would affect what we're doing here because that's another allegation that you have to admit to. But they're not a part of the allegations that you admitted to today. So I will wait to see those allegations, but I will follow the recommendation of alcohol education, ABR no. Anger management would be at Cristo Rey, that's been scheduled. You're to test 1 time a week per AbraHealth. This has a date last tasted of April 8th. The current balance is $705. The probation end date is September 25th, 2025. We're going to continue you on probation. I'm placing the 4 days in abeyance. You are ordered to do an outpatient treatment upon any future positive tests. So if you positive test, and that's before the allegation comes to us as an allegation, you're to do whatever the probation says in regards to that test. So outpatient is ordered on any future tests.
So now I got proof of testing on my phone.
Show that to the probation agent. For some reason, an indication is probation saying you didn't test yesterday. If you did, work that out with probation, okay? So the only change is continued. The probation recommendation is indicated by Mr. Harris in the pink sheet. The request was a weekend minimally suggested. I've held 4 days as a technical violation in abeyance. So that's what you have hanging over your head. And I've ordered the outpatient. Mr. Richardson, this is the first technical violation, all right? So, and you're up in September. It's only 6 months, but it's on an assaultive crime. So if you can make it till September, this is done with, all right? The 6 months probation. If not, then all the things that we're worrying about are going to continue to be a problem. Your probation is going to be extended. We're going to look at to see if maybe there is a problem with a substance here. And as you can tell, that's 80% of what I deal with. Okay, that's really what we're dealing with is a substance abuse issue. And you may have already tested, you may have already tested positive. I don't have those allegations in front of me. Look to your probation agent to see if you can resolve this. But do you have any questions of me concerning the probation violation recommendation or the sentencing based on that recommendation?
Regarding the testing, is there any way I can test here? Because it is a financial burden.
Check with your probation agent. If they say you can test here, that's fine. It's really, it's Miss Bayless, so it's up to her.
I told her already.
Yeah.
She still told me like,
But
you gotta deal with
but ultimately, it's her call. Where she needs to find the testing is where you've got. So ultimately, it's up to her. I think you've got to clear up some of the things that in the past, the allegations, or else we're going to be here in a couple of weeks with the same allegations. All right, sir. All right, Mr. Richardson, you're all set. It's good. Thank you for your appearance today.
Thank you, Your Honor.
Thank you, Mr. Harris. All right, was that Mr. Castillo was already, yeah. So did she go get Ayers, Ellis, Gonzalez, or you don't know?
Oh, yeah.
Mr. Ned, do you know who Megan went to go get?
Yes, Gonzalez. And
Anthony Gonzalez?
can we be in chambers about that? Very briefly?
Yeah, well, and with Mrs. L, we can.
Yes, she was aware.
Judge, may we approach on Gonzalez?
Yeah, you can approach or we can meet in chambers.
Do it.
Okay. All right. So Mr. Bach, you're here for Lansing Automakers?
Yes, Your Honor. Looks like I have three
All right.
matters.
And that has to do with Bobby Bradford, is that correct?
Yeah, Bobby Bradford, Ajayi Perkins, and Jordan Mata.
All right, is Bobby Bradford here in the courtroom today? I don't see Bobby Bradford. Let me pull that case up, because that might be a discovery default, and we can move
Yes,
that case.
I believe there was a bench warrant, and he was to provide documents, and now he's not here again.
Right.
That's it.
So we can start on the 230 civil files at 340.
Yeah, I'll just leave that one alone.
All right, while we're bringing up,
I'm good. Oh, yeah, you should. That's great. I'm gonna be there as soon as I'm done.
Because I need a date. Doesn't have a date of contact. That's who informed us.
what a nightmare schedule.
Do you need the actual first page of the violation?
Just a little bit.
Do we need that?
And we already had a packed day. So that's 2012. All right, Mr. Bach, let's call that first case and we'll go back to criminal. All right, so we're on the record in 12-02473. That's Lansing Automakers versus Bobby Bradford. Will the parties please introduce their appearance for the records? Mr. Bach.
Yes, good afternoon, Your Honor. Ronald Bach here for LAFQ.
And this is the time set for a discovery proceeding. As Mr. Bach indicated, we did have a control date for discovery set on this date. All parties met prior to the hearing. We canceled an initial warrant that was set because the party showed up. And then Mr. Smith indicated that there was additional material that was supposed to be sent over for discovery. We set this as a control date. I do not see Mr. Bradford in the Zoom courtroom. There's nobody by that name in the Zoom courtroom or regular courtroom. And I don't know if Mr. Bradford nobody's in the hallway. It would appear that Mr. Bradford has failed to appear for the discovery proceeding. It is 3:41. Mr. Bach, how would you like to proceed today on the defendant's fail to appear for the discovery proceeding?
Yes, I would request a bench warrant, Your Honor.
Right, a bench warrant concerning the non-appearance is verbally ordered, and you will follow that up with an order, Mr. Bach. What is the underlying debt in the matter?
Well, Your Honor, I was not given the current balance.
Yes, I have a previous bench warrant was scheduled PR for $300. That was on a previous occasion. I have the debt. The complaint has the debt of $1,500. Does that sound right? 1546. All right. All right.
Yes.
I will await the order to follow on the non-appearance for the discovery. Anything else for the record in 12-02473, Mr. Bach?
Yes, you didn't say a bond amount.
The bond will be set at about $300 cash.
$300 cash. Thank you, Judge.
Thank you. All right, so we're all set on that file. And then Mr. Nett, are you ready on Mr. Gonzalez? All right, so we're on the record in docket 24-02869. That's people of the state of Michigan versus Anthony Gonzalez. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Ned.
George Ned, APD, on behalf of my client, understanding to my right.
And sir, you are Anthony Gonzalez, is that correct?
Yes, sir.
All right, thank you. This is the time set for a probation violation hearing. Mrs. Zell, how are we proceeding, or would you like to defer to Mr. Ned?
Your Honor, I would just like to make a brief record that the people did have some witnesses here and we're ready to move forward with that probation hearing today, or probation violation hearing today. We have been made aware that at this time, the defendant is choosing to plead no contest to this violation. I will leave it for Mr. Ned to add to the record.
Right. And my understanding of the no contest plea is that any admission may go towards an additional, what could be an additional charges being filed. Is that a fair statement, Mrs. L?
That is a fair statement, Your Honor, even though our office has no indication of additional charges at this time.
All right. Is that your understanding, Mr. Ned? And then you can supplement the record.
Yes, Your Honor, as a precautionary matter, I indicated to my client, we are not going to be pleading guilty to anything. A no contest plea prevents that from happening and potentially prevents any charges for, or any statements or anything he says to be used at a later proceeding. So I believe at this time, given the circumstance and the evidence potentially to be presented at a hearing, we opted in and indicated that we are going to plead no contest. It's my indication the prosecution has no objection to a recommendation of 80 days and to continue probation. And we just hope that you follow that as well, Your Honor. It's not, I don't think it's a killer brew, but it's more like a.
We had a Cobb's. We
mini
talked
Cobb's.
about it. So, all right.
Like a mini, yeah.
All right. Is that a fair statement, Mrs. Zell? Everything that Mr. Ned just said.
It is a fair statement, Your Honor.
All right. What am I going to use for the factual basis for the no contest plea?
Your Honor, we have highlighted a portion of the 54A District Court Probation Review hearing update from, I believe, probation agent Jody Bayless, and a screenshot of one of the contacts that is alleged.
All right. Thank you, Mrs. Zell. All right, may I inquire of your client, Mr. Ned, of his rights on this file?
Yes.
Mr. Gonzalez, you understand you have a right to a hearing in this matter. You are represented today by Attorney George Ned, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
That is your wish today that you plead to the technical probation no contest for various legal reasons, but other reasons are that may end up in additional charges and you don't want to admit anything. Is that a fair statement, sir? All right. All right, and we'll be using the updated hearing update, case 2402-869, that was filed by Ms. Bayless. Is that a fair statement, Mr. Ned?
Yes, Your Honor.
And Mrs. Zell?
It's a fair statement, Your Honor.
Okay. So the allegations that we're working from, I have allegations. I want to make sure that we're on the same. Because there were a few allegations on this. That would be violation 12 and 13 for dated May 16th. Is that?
Yes.
Is that the one you have? I have violation 6, 12, and 13, and they're dated by Jody Bayless on May 16th.
I have that, yes.
That is what I have here.
All right. Six, 12, and 13. All right, and I am in possession of the hearing update for 2402-869 from probation officer Jody Bayless. That there's been third-party contact with the complaining victim from Mr. Gonzalez. That the victim reached out on May 16th and June 2nd regarding safety. A PPO was filed on May 6th. All right, so let's do this in order. On violation 6, there's an indication that the defendant has failed to make payments. The last payment was made on March 5th, 2025. That doesn't have anything to do with the factual allegations, but that is a technical probation violation. Do you admit that the balance was $815 and that your last payment was made on March 5th? Okay. So that's admission to number 6, non-payment. That the no contest finds that third-party contact as of January of 2025 from has the victim and the victim's mother reported additionally instances where defendant Mr. Gonzalez has been using other people for third-party contact to try to reach the victim since January 2025. And that no contest is indicated on violation number 12 as being a violation of probation, non-technical. That would be number 12. And is the on number 13, there's threatening behavior via electronic communication. Is that also, that is part of the text? Or is that a part of the?
That's part of the no contact.
Okay. So that would be the third party no contact. Is that a fair statement, Mr. Aned? Coming from the no contact, from the probation report, indicating that there's been additional contact from through a third party of the victim.
Repeat what you said, Your Honor.
So the violation number 13 is defendant engaged in threatening behavior via electronic communication with the victim. Is that part of the no contact through the third party, or is that something that I would need additional facts? Because I don't see it as a part of this fact pattern.
Well, Your Honor, I think the screen, if you could look at the screenshot, then there's a message that indicates unblock my number, or which could be viewed as.
I don't see. I only have that. I do have contact on April 21st between Mr. Gonzalez and Alaya Ashalal pursuant. So if that's part of the factual basis, we can take that. All right. So that would account as a no contest for April 21st, that the defendant did engage in electronic communication with the victim, and which the victim could indicate was threatening to her on violation 13. And that would be an admission via no contact, via the no contact plea, no contest plea. All right, with that understanding, are you ready to proceed to allocution, Mr. Anand?
Yes, Your Honor.
All right. So I find the no contest plea to be fair, to be full, fair, and accurate concerning the factual basis, and I will indicate that the defendant has admitted to the allegations in the probation violation petition for technically violating violation 6 and for non-technical violations of 12 and 13.
Just so I heard you correctly, Your Honor, he admitted to the non-payment, but you found him responsible for the other two.
Exactly. Yeah. So admission to number 6, and then no contest as to 12 and 13. Allocution, Mr. Anand.
Thank you, Your Honor. Due to the due to the potential issues going forward, I'm going to keep my allocution and my client's allocution very limited. We did have a long conversation in the jail earlier today before the hearing, and he did prepare a very long, thoughtful letter, but due to the potential circumstances, I opted in for safety reasons not to divulge into that. He does have one portion he wishes to talk to you about, Your Honor, or at least read off to you in regards to his progress while on probation. It's very brief and narrow. And I just ask that you follow the recommendation in contemplation with the cops that we had. 80 days is appropriate, and continuing probation is what we're asking for at this time.
Okay, all right. Thank you, Mr. Ned. Mrs. Zell, before I inquire, Mr. Gonzalez, do the people have anything on the probation violation allocution sentencing?
Yes, Your Honor, just briefly, we would like to just reinforce what Ms. Bayless said in her update to the court. The victim and her mother in this case are scared for their safety. They have come back to our office asking for help, asking for protections to be put in place. And that is why we are asking for those 80 days in jail today, followed by a continued term of probation. Thank you.
All right, Mr. Gonzalez, is there anything you'd like to read to the court or tell the court before the court passes sentence?
We'll leave this on just for safety concerns, Your Honor.
But this has to do with the admissions of guilt and the no contest plea recording. Mr. Gonzalez, you understand the nature of what's going on here, okay? This started out as a stalking case, and the full and part of stalking is no contact. Direct or indirect, third party, no third party. And then we have some contact, and it blows into this hearing. And everybody, you're under the microscope for everybody, okay? You're under the microscope for me, for the prosecution, probation, because any contact at all is going to be heightened to a level, okay? That being said, the recommendation is not to cancel probation at this time, okay? That's not the recommendation, but it is to impose jail time, okay? You've already started it. You started it last week at the arraignment. We'll continue it. So I'm going to order 80 days in jail pursuant to the cops. Jail. We will continue on probation pursuant to the recommendation, and I'll indicate that for the record. So 80 days in jail. Once you're done with your 80 days in jail, treatment at MINS, DV, ABR. You're not required to do parenting classes. This is a first technical violation. You've not had any technical violations before, but because you pled on, have you pleading on October 25th? Testing at AverHealth 2 times a month per AverHealth. Any current balance can be paid at the end of probation. The ending date for probation is October 19th, 2025. I'm not extending that at this time. But you're to serve the remaining 80 days in jail. Credit for, I think, from arraignment is 7 days, right? 10 days in jail. Okay. So it's 80 days in jail, credit for 10 days on this file. Once you're out, you're still on probation, so still be in contact with your probation officer, Ms. Bayless. All right, sir?
Yes, sir.
All right. Anything else for the record in docket 2402-869? Mrs. L.
Not for the people.
Mr. Net.
Yeah.
All right. Thank you for your appearance today. You're all set, Mr. Gonzalez. I'll go back. I'll lose that if you give the no contest.
Thank you.
Is Malaya Gonzalez present? Malia. So we have Ayers Ellis, Malaya Gonzalez, and we know that Mr. Ray is not here.
Correct, Your Honor. I heard rumblings that Ayers Ellis was in custody.
Yeah. But we know that's the last one in custody, and then Gonzalez and Ray. So let me know when you're ready to go on those. And then I'll start calling some of the civil cases. All right, so we're on the record in docket 14-02227. That is Capital Alliance Financial versus Shamaria Houston. Will the parties please introduce themselves for the record? Do I have a representative from Capital Alliance?
Yep. Good afternoon, Your Honor. It's Craig Fay, P81401 on behalf of plaintiff.
All right, thank you, Mr. Frey. And is there a Miss Houston here? The Shamaria Houston. I do not see Shamaria Houston in the Zoom courtroom. Nobody answers by that name in the physical courtroom. We should probably, Mrs. L, I'm going to borrow you to call or to see if anybody's in the hallway named Shamaria Houston.
There
Flores, Lieutenant needs to go back on Gonzalez when he's released.
After 80 days, no.
Or Heather.
Tether, absolute tether.
That's what I thought,
Yeah.
but I.
Don't remove it. And I do have, this was a motion to set aside, I believe, wasn't it?
Nothing.
Thank you, Mrs. L. I hate to do that, but I don't know any other way. All right, so it would appear that we previously met on April 1st. This was a motion to waive or remove remaining balance. This, we treated it as a motion to set aside the order that was filed. I believe it was filed. Let's see, capital lines.
Right, Your Honor, I can kind of give an update.
All right.
So,
all right, Mr. Fay.
yeah, so at the last hearing, that was April 1st. So it was there was an agreement at the hearing that if the defendant paid $500, we would go ahead and satisfy the judgment. So it looks like as of yesterday, we just, I should say yesterday, we just received the $500 payment yesterday. So long as that clears, we'll get that satisfaction judgment filed.
All right, so that was on, because I have a notice of hearing on Miss Houston. And then a lot of information concerning, that's 24 zones, that's a different case. All right, but right now you're satisfied, Mr. Fay, that there's been an agreement between the parties.
Correct.
The parties, and if you would like, I can set this for control date to make sure that you receive the payment. If you have not received the payment, we can just go ahead and meet today. If we don't need the control date, you can let us know. Will that work?
I would say I don't think we need the control date. We did receive the
Okay.
payment yesterday, so it's more or less we
All
just
right.
need a few days to just make sure it clears.
All right, okay, so payment has been made. And so you'll be submitting a dismissal concerning this case after the payment's made, is that correct?
A satisfaction and judgment, Your Honor.
All right, so I will await the satisfaction and judgment to be filed with the court. So that orders to follow, and then you would let us know if it doesn't work out, we'll just reset the date for a hearing date. But I'll wait to hear from you. If not, you can file the satisfaction and judgment, and we should be all set.
Perfect, Your Honor. That works.
All right, anything else for the record in 140222227, Mr. Fay?
No, Your Honor.
Okay, you should be all set. Thank you for your appearance today.
Thank you. I do have one more, so I'll go on.
All right. That was. Which one is the last one? Oh, yeah.
We have two
Ayers.
Ayers and then.
So did she go get Ayers?
I think she is, Your Honor. I need time to speak to.
And then Ray is not here, and is Malaya Gonzalez here? So we have Anthony Gonzalez that we just did, and then we have Malaya Gonzalez. That's a probation violation arraignment. You wouldn't know. Because that's.
I wouldn't know about
Yeah.
that, right?
I don't think she's here. She's not. So we'll leave that till the end.
And then also, Your Honor, the Ray, which is a non-public.
Yeah, they're not here, are they?
If he's not in custody, no,
I don't
I've
think
tried to
so.
reach out yet.
All right.
So that'll be a bench warrant.
Yeah, we'll put those on the record once. But let's go ahead and we'll wait for Ayers Ellis to get here, and then we'll put on 2407125. That's Finance Forsyth versus Anthony Lloyd.
Good afternoon, Your Honor.
Appearances. All right, Ms. Dillo, and you're Anthony Lloyd, sir? You can have a seat right there. All right, so this is 2407-125. Ms. Dillo, your appearance for the record.
Thank you, Your Honor. Jennifer Dillo, appearing on behalf of the plaintiff.
All right, and sir, you are Anthony Lloyd, is that correct? Thank you. This is the time set for a hearing for entering judgment. Is this a summary disposition or? Let's see. I have us previously meeting. I don't have us previously meeting. Ms. Dillo, what's the nature of the file here?
Yes, Your Honor. In this case, the defendant filed an answer, and the court sent my office a letter indicating that if we were agreeing to the $150 per month payment to submit a judgment, we did that. It's my understanding there was an issue with the court costs on the judgment, and we did review that after the court set this hearing. There was a $20 motion for second summons that we were or a motion for second summons that we were about to file prior to the defendant being served. And that motion fee was inadvertently included in the court costs. So the correct costs should be $210.12.
All right. So the judgment to be entered would be, give me that amount again.
Yes, Your Honor, and it's $997.09 in damages, $210.12 in court costs, statutory attorney fee of $75 for a total of $1,282.21.
All right.
And we did agree.
Mr. Lloyd.
Oh, I'm sorry.
So the request was from the civil department to lower the cost because of that, because of the additional amount. Is that your understanding, Ms. Dillo?
Yes, Your Honor. We inadvertently included a motion that was not filed.
Okay. So you will submit. So, Mr. Lloyd, is that your understanding? All right. So you will submit an amended order to the civil department, and then they will provide it for my signature. Ms. Dillo, you'll follow that up with an order with the amended amount?
Yes, Your Honor.
All right. That seems like we did a lot of work for a very little substance concerning that. But I will verbally okay the order and then I'll wait to sign it. Mr. Lloyd, do you have any questions of me?
Make the payments to this?
You would still make the same payments to.
I know,
Yeah.
tell me where.
All right. So, Ms. Dillo, do you have an indication of where Mr. Lloyd is supposed to make the payments to?
Yes, Your Honor. The payment should be sent to the address on the pleadings, and if the defendant would like, I could also send him a letter with the payment information.
So we'll send it out. They'll be sent to you in a letter. So yeah, Ms. Dillo, send it out to a letter so Mr. Lloyd has it all, and then he can start making the payments in accordance with the agreement.
Thank you, Your Honor.
Thank you, Ms. Dillo. You're all set. Thank you for your appearance today, Mr. Lloyd.
I had a meeting on the 11th. Oh, were you? Okay, so I don't know what happened. Yeah. Okay, well, I don't know what happened. That's weird. Guys didn't know wrong or something. I won't put on that. We got the record. All right. Are we here for a sentencing on Mr. Ayers, or is it a bond violation?
It is a sentencing.
Okay. And there's no PSI, is that correct?
Sent you what there was.
Yeah.
Good.
There's something up there on that, Megan. Kind of it's being sent to more than one app, so I have no idea what that means.
Because we're live streaming on YouTube.
Okay, perfect. All right, Hanedra. And
Remand.
Sorry. 07800.
Going back to civil.
Yeah, that's your going back to civil. All right, so we are on the record. 7800. And the plaintiff is Hanedra White and the defendant is Ian Barber and Barbara Keating. Is that a fair statement?
That's correct, Your Honor.
All right. And you are Hanedra White, is that correct? All right. All right. So ma'am, you are Hanedra White and you are representative of Barbara Keating and Air. Mr. Small, is it?
Yes, it's Mr. Small, Your Honor, but Ms. White is in pro per.
Okay.
Civil matter.
Correct.
And I represent Mr. Barber.
You represent Mr. Barber and you, so Mr. Barber and Mr. Barber is also from Barber Heating and Air, is that correct?
That's correct, Your Honor. This is a objection to the entry of an order under 7-day rule.
Right, right. So, all right, so we previously met on May 22nd, 2023. This was the defendant failed to appear. So I do remember so I have defendant failed to appear for motion, default granted motion, FTA of defendant, but you actually filed the motion, didn't you?
I filed the motion, that's correct, Your Honor.
Okay, and that was to set aside the default or
No.
that was Miss White defaulted?
No, well, we filed a motion to permit us to enter plaintiff's house to inspect an electrical panel and the outlets in the home, okay? And we provided service of that motion on plaintiff. We had the hearing, court granted the motion.
Right.
I submitted an order under a 7-day rule. Ms. White has objected to the entry of the order.
And was Miss White at the original motion that
She did not appear.
It was a default, wasn't it?
Well,
that's why my notes are confusing
You
me.
said to mention default,
Okay.
so it jogged your memory that she did
So-
not appear.
That,
received anything.
all right, so you're indicating notice was a problem.
Yes, it
Okay.
was.
We can look that up. Okay. Plaintiff. So you followed a motion under the 7-day rule, and that's why we're here on the objection to that motion.
Correct.
And that objection was to get into the house.
Well,
Or
the objection to the entry of the order.
Okay.
Right.
Well, Miss White's objection is to the order, but the default was to get into the house. The motion was.
The motion
so that you
was
can
to
check
allow
the
us to-
electrical.
Look at the electrical panel and the outlets in the house, which she said are not working.
All right. And then what you're indicating, Miss Houston, is that, or Miss White, is it Miss White?
Yes.
Hanedra White. You're indicating that you never got notice of that hearing date.
Right.
All right, now.
I'm ready.
So that is the reason you did not show up for the motion.
Correct.
Because that's the first thing we got to figure out is how do we get here and why you weren't here last time? Because it's really an objection to the order. You were default. I mentioned default last time because you weren't here to indicate why you'd object to an order coming into the house. And so I said the order's good. You're not here. Now you filed a motion of the 7-day rule, which means you have 7 days to object, and you've objected to it, which is why we're here. I just want to make sure that notice was properly sent to you. So that's your indication is I don't know why we were here.
I don't see where she got
All right. There's no indication that you would have received notice on this. Mr.
Yes, Your Honor, I believe
Small.
that we originally filed the notice of hearing on June. In any case, let me approach the court. Give it to the court. I filed it twice, once attached to my brief, and once before the hearing.
You did the hearing.
Well, I telephoned because we had a trial date on the 1st or 2nd day of June. And I was told that I needed to get it filed now with the notice of hearing so that we could appear on that date. We were on the docket on that day.
You would have to put it at the judicial office.
That would have to go through you.
Yeah, and it didn't. Because all this is through my file is the indications. I didn't know anything about this, so he just explained it. I can figure it out.
So the notice of hearing is set for May 22nd.
Correct.
But it didn't come through our office.
It didn't come through me and it.
Yeah, so, and then they put it on the docket. This isn't the first time this has happened. Then we put it on the docket and there's a so I don't know, I can't indicate that Ms. White got notice of that hearing because I don't know what they did with it.
Well, we provided directly with proof of service.
Correct, but that, if we don't have anything indicating on JIS that, then we got a problem.
And
No.
they didn't
I
come
just
through
did what I
us.
was told.
Absolutely, you are correct, sir. All right, Mr. Small, so let's do this. You can have a seat, sir. So we still have an objection to the motions set aside under 7-day rule. We can set this for, I'm going to grant the motion set aside. I don't have it. I don't have that we give you notice for the default, okay? It appears that there's some discrepancy between whether you can get in the house and get to the electrical that you need to, that you want to work, because you don't want to let them in the house.
I have, I went and got some quotes.
It really does, yeah, I mean, that's fine, but your quotes are be meaningful if we have a hearing, so you could prove your quotes. I put whoever on the stand and we could talk about the quotes. Right now, Mr. Small just wants to get in to see what he needs to fix. And you're indicating that you were told that by the city inspectors that they shouldn't be in. That sounds to me like we're going to have a hearing then on it.
Are we talking about the trial or are we talking about a hearing on whether I can go look at the panel?
I think right now we're looking at a hearing on whether you can look at the panel or not.
Okay.
You know, that's what it sounds like to me. Unless she's willing to look at the panel, we'll just call the witnesses and then I'll make a decision and we'll set the time frame.
I have a witness that was already in my house from.
Make sure he's here next time then.
Right there.
Yeah, make sure he's here next time. This is not set for hearing on that. This is set for an objection to the order, because and the objection to the order is because you didn't get proper notice last time.
It's been hard because I'm dealing with a lawyer. I'm not a lawyer, so
Right.
it's been hard to talk.
I completely understand you're in pro per, but I've seen enough that the notice is a problem. There's a problem whether you got official notice. Mr. Small, I think, did everything he's supposed to do. I don't know if you got it from the court or not. And we can usually tell that right away. So let's set this for hearing, but we're going to put some time aside for it because we're going to take some testimony. Because really, we're just having a hearing on whether Mr. Small can see what he needs to in order to make the repairs that he's made, that he's indicated he needs to make. Is that correct?
Well, it's even more basic than that, Your Honor. Ms. White is telling us in the complaint that the electrical outlets don't work. And she's implying that they don't work because the electrical panel was defectively installed.
Right.
All right. I don't have anything to indicate that it was defectively installed.
Except me.
But yeah, sir, you're going to have to leave the courtroom.
Oh, I can't.
Go ahead.
Excuse me, Your Honor.
No, ma'am, you got to stop talking. I'll let you talk, okay? but your witness just shouted out in the courtroom, so he gets to leave, all right? You can continue, Mr. Small.
And I don't believe he's ever looked at the outlets. So we need to look at the outlets. We need to see whether or not, the reason the outlets don't work is because of the electrical panel that my client subcontracted to have installed by another electrician. Okay.
And you're indicating that you're not willing to provide access for him to see what he needs to fix because you've been told that that was not put in correctly.
Yes, by the city of Lansing. I have a paper, a letter from him, and I just feel like since I've been allowing him, he has not taken care of the situation, and it's been over a year now.
All right, that's fine. We're gonna have a hearing on all that, okay? Because the objection to the order is for just access now at this point. Would that be a fair statement, Mr. Small?
Right, and Your Honor, I've looked at the stuff from the city and I looked at this stuff from Mr. Jones, the gentleman was here. What happened is the electrical inspector goes out and Mr. Jones goes out and they said, you got to bring the electrical system of this home up to code. Okay, well, my guy's an HVAC contractor. He put in an air conditioner. So she may well have to bring her house up to code.
Right.
As Mr. Jones is going to be happy to tell you. Right, but I just want to know, was the panel installed correctly or defectively?
Right.
All right.
Right. And by your client or by someone else?
Well, it was by the subcontractor, okay. No question about it, because we're not electricians.
Okay.
But as a starting point, did that electrician defectively install it? Number one. Mr. Jones will tell you that you got to pull a permit every time you put in a panel. That's true.
Right.
And then the electrical inspector comes out. That happened. And then they tell the client, you got to bring your house, once you do this, you got to bring your whole house up to code. And that requires a lot of stuff, which costs about $7,500 here. So all we want to do is determine whether the panel was defectively installed, why the outlets don't work.
Okay.
That's it.
Well, let's have a hearing on that. And you indicated several Lansing code compliance officers told you something, right?
Correct.
So what are their names?
Their names is, I have their names right here.
Because I want to know what they told you.
And I don't know.
Yeah.
He's got to bring her house.
We don't know what was told you, so we don't know what their name. So you're gonna have their names and spell them out for me. But we're gonna order them for the hearing, okay? To be here during the hearing. If I can make this work. Oh, there. So City of Lansing code compliance officers. And we'll get their names to make sure they're available or make them available. So City of Lansing code compliance officers. Because I think we all want to know what you were told. What are their names, ma'am?
Their names are, one is Mike Schultz, that's M-I-K-E. Schultz is S-H-A-L-T-Z.
Okay.
The other one is Eric Simmons.
Eric Simmons?
Yeah, Simmons, just Simmons, S-I-M-M-O-N.
All right. So Mike Schultz and Eric Simmons will be told from the city that they should be at the next hearing. There's been no order under the 7-day. It'll be adjourned to the hearing and we'll set some time aside to take some testimony on it. Ma'am, you should bring in any other witnesses you want the court to consider, like the person who just left. If he's going to testify, what's his name?
Russell Jones.
And then he would be subject to cross-examine of Mr. Small, who would get some more information concerning some questions he has as to when the inspection was done and what city commissioner told you what. Because right now, the only thing we have is that you were told something, and that's why access is being denied. And right now we're trying to figure out why. Okay. All right, Mr. Small, is there any record you wanted to make? Supplemental record. We'll get you a date, and I want to make sure that date has enough time that we have. As you can see, we get a little backed up every once in a while, so we want to put 2 or 3 hours aside for it, and make sure it doesn't conflict with anybody's schedule.
That's fine, and the reason I started this process is because we were staring at like a June 2nd trial date.
Right.
So I started back in May to try to get out there so we'd be ready for trial.
Right.
And now we're here.
Right.
Past mid-June, my June was awful. My July is worse.
All right, well, let's get a date that works and we'll figure it out. I think we use Thursday or Friday afternoon for most hearing dates. What's that? Okay, civil will work too. The civil afternoon?
Yeah, July 28th at 1:30.
Does July 28th work for your schedule?
I made a mistake. I left my phone in my car.
Okay,
So
do you want to go get your phone and bring it back so we can
it's
get
a
a
long,
date?
hot walk and why don't we just have the notice sent out? If I have a problem, I'll contact
All
the
right.
court.
All right, so we'll get a date.
Well, I need to let the code compliance officers know, so I don't want to send out an email. She's gonna turn around.
Then, yeah, I don't know.
Can we just push it out?
Yeah, I can do it in, what's the jury trial, the next after July? Because then we are looking probably at a Thursday or Friday afternoon.
And I have a federal court trial starting in August, middle of August.
Okay. And I know August is a little, because I know I'm off, I know I'm at a conference one week and then
August 25th.
August.
That should work.
Okay. All right, let's set it for August 25th at 1:30.
And I'll get right back to the court if it's a problem,
All
so
right.
we don't have the code compliance.
So we will set it for August 25th at 1:30 for civil formal hearing on the order for access.
That's a Thursday?
And no, that is a,
Monday?
did you have the 25th is a Monday?
Okay.
Yep. Monday at 1:30, and that would be on the 7-day order for access, I should say. And then what we'll do, ma'am, is I will make sure that code compliance, Mike Schultz and Mr. Simmons are here. You're gonna have to take care of the rest of your witnesses, all right? So bring them here. And then Mr. Small, any witnesses you want should also be here,
Sure.
as you know. All right, so we've set it for August 25th at 1:30. Any questions concerning what we did here today, Ms. White?
No, I think I understand it. I did, however, receive this and I wasn't sure what it meant. It was like a bill to pay someone or barber.
No, that's from Calhoun County.
Yeah, that's a different county.
Why would, I don't know why they, okay,
Yeah.
I'll just call.
So
them.
you might want to call them to figure out Calhoun County.
Okay.
Any questions, Mr. Small?
May I have my notice back?
Yes, and you can get it from my court officer who also has to, I think we're done because Mr. Ray is done, right? That's Ayers Ellis. So yes, the answer is yes to your question. All right. We'll see everybody here on August 25th. Thank you for your appearance today.
Once she gives them to me, I'll give them to you. I don't think she has them.
All right, so it's gone. That is White and Mr. Small, you can take back your.
Oh, that's all I need.
Yeah, you can take back here.
Then I'm good.
Oh, you want your notice?
Sure.
47800.
Okay.
All right, thank you for your appearance today, Mr. White. We'll see you on August 25th.
Thank you, Your Honor.
Right, is this Ayers Ellis? All right. We're just wrapping up with our 130s. All right. All right.
Sorry, we'll finish this one. Sorry.
All right, so we're on the record in docket 24-03097. That is people of the state of Michigan versus Michael Ayers Ellis. This is set for sentencing today. Appearances for the record, Mrs. Ellis.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Knapp.
George, and then APD, I'm half my client is saying to my right.
And sir, you are Michael Ayers Ellis, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a sentencing in the matter. Mrs. Zell, is there any restitution on this matter?
There is no restitution, Your Honor.
All right. Mr. Annette, have you had the opportunity to go through the pre-sentence report with Mr. Ayers Ellis?
Yes, Your Honor, just to make a brief record, I tried to reach out to my client back on the Polycom about a week ago. Apparently he was on the Polycom. I logged in, he was in the room I was given. So I did try to meet with him, wasn't given a chance to be able to. So we did hear for about 20 or so minutes before we went on the record. Everything appeared fine. There's no corrections, deletions to the report except in regards to the detainers pending charges, the 52I District Court on the first page. He said that is some type of error. He does not have a warrant or anything going on in the Oakland County area.
All right. I will indicate that the defendant contests the pending bench warrants out of 52-1 District Court.
Other than that, Your Honor, no deletions, additions, or corrections.
All right. All right. Allocution, Mr. Annette.
Thank you, Your Honor. Let's just start really briefly. Obviously, my client is in custody. We talked a little bit about that, and he can explain a little bit further. Basically, the address he had on file, I believe was an whole address, was an address where he just got mail. It was an individual, I believe was a friend. Actually, you know, you explain it very well. I'll let you explain it if that's okay.
Okay. First of all, I'd like to apologize to the court for missing my court date. Like my attorney was just saying, it's the friend's mailing address that I use. Right now, I'm in between housing. I'm on a housing list, basically in the process of my own place. I still work, but it was a technicality with me getting my mail.
Essentially, he gets the mail sent to the address because he's bouncing houses, and he never got the notice. Apparently, he got remanded to go to a PSI. He did. It got released. Got a court date for sentencing and missed it because he was in Troy for his granddad because he got sick. And it slipped his mind, and when he found out about the warrant, he got scared, and then got picked up recently on a traffic stop, I believe. So, Your Honor, I believe there's some mitigating circumstances of the failures to appear. Based on looking at the recommendations, the probation recommends, despite the failures to appear, he's still a good candidate for an 8-month probation recommendation sentence. He's asking for that. He works in the area full time at the hotel off of Lake Lansing. He has a job. He has a girlfriend. He has a life. He has a vehicle, Your Honor. He wants to do probation, and I believe, based on the charges and the recommendations, I believe probation is appropriate. He's wanting, Your Honor, to prove that despite the failure period, that he will be a good candidate for probation. Thank
All
you.
right. Do we have an updated address that's a good mailing address?
Yes, I can state that right now, Your Honor. It is.
Because we have the West Willow address.
Yes, that's the address. And I have an updated phone number ending in 9832 if court wants.
I just want to make sure that we have a good address for the court file. 608 West Willow, apartment F112.
Yes, sir.
60.
He's right. He got.
Oh, 608 West Willow. Okay. He did tell me that he did not know it exactly. Okay, so 608 West Willow, Your Honor.
48906. Yes. Okay. All right, that'll be used for the notification purposes. Ms. Izell, do you have any? Before I seek allocution of Mr. Ayers Ellis, anything from the people on this case?
Yes, Your Honor. Two things briefly. One, regarding the failures to appear. Unfortunately, in my notes, I have noted down that there were no reasons given at those times for the failures to appear. It is a little concerning that now there are reasons when before there were not. Additionally, Your Honor, this plea was taken back in November of last year, and we are now about 7 months past that, doing the sentencing due to the failures to appear on the sentencing and for the pre-sentence investigation. However, Your Honor, we did agree to no upfront jail, and we do believe that that should be considered here. We do believe that the recommendation should be followed. We do have concerns that probation will be successful based on the failures to appear.
All right, thank you.
Yeah, one note my client wanted to inform me. He said that one of the failures to appear, he did call, and he was informed he was 10 minutes late and they would not fix it. A warrant did enter. He did clear it, I think, that day.
Yes, sir.
With you, Your Honor. And then they gave him a new date. So that's for one of the failures. He was a little late. And he did clear it that same day. He said he was in front of you.
All right, thank you. Mr. Ayers Ellis, is there anything you'd like to say to the court before the court passes sentence?
Yes, sir. This is so not like me. First of all, I would like to say that I would like to truly apologize because I know I was given a chance with the opportunity to be on probation. I am in a place in my life where I'm more humble than I was before. I calculate my steps a little better than before. I'm not perfect, but I am working to be better. You know, I don't do a lot of knucklehead stuff that I used to, and I do want better for myself. And I know I can hold down a job, which I proved to myself. I can separate myself from different crowds, which I proved to myself. And I just want to have the opportunity to prove to this court that I can do better, opposed to everything that you see that's on paper and that you heard.
And despite him being in custody for about 2 weeks, he has indication from his girlfriend, who does also work there, that he still has his job. That's how much of a good community member he is.
All right, and he's working, what's the name of the employer?
Homewood Suites.
Okay, that's off of Lake Lansing.
Yes, sir, by Walmart.
All right. All right, anything else for the court to consider on judgment of sentence from the people, from Mr. Ned, or from Mr. Ayers Ellis?
No, thank you, Your Honor.
Mr. Ned?
No, Your Honor, thank you.
All right. All right, well, Mr. Ayers Ellis, you're not a kid and I'm not going to treat you like a kid, okay? You have a CCH that goes back a bit. But I mean, it's over 10 years old, and there's an indication of some Department of Corrections, 2012. I'm going to follow the recommendation, okay, for probation, mostly because I think people can change over the course of time, okay? I really do think people can change. But you have to understand, Mr. Ayers Ellis, that you are under the gun, okay? Because all we're looking for is for something that to go awry, and then we'll say, well, look, I told you I was right because of the past. I don't look at life that way. I don't look at it. My framework's not developed that way, but it's an easy argument to make, and we tend to go towards easy rather than hard, okay? With that understanding, I do think I'm going to follow the recommendation because I do think that everybody deserves chances, okay? And I believe that that one way or another, we can, as a part of probation, that you could really, as knowing the system, you understand what a break this is, all right? And you can follow probation and then do everything you're doing right now. I don't want to get you off track, all right?
Thank you.
All right, so I'm going to order for the guilty plea that was found on November 4th, 2024. The attempt R&O, that you spend 60 days in jail, credits given for 45 days previously served. I'll suspend the remaining 15 days. Upon successful completion of probation, we'll set fines and costs, fines at 200, cost at 200, crime victims' right fee of 75, state minimum court cost of 50, and probation at $30 a month at $240 a month. And then I'll give you a total for that. That will be done. That would be due at the end of probation. All right. So that'd be 400 plus 125 plus 240, and that'd be 765 at the end of probation. You're placed on probation for 8 months via Zoom. That is the request of the officer, of the probation agent. And I believe the person who wrote this is Jody Bayless. As a part of probation, no assaultive or threatening behavior, no use of possession, alcohol, marijuana, or controlled substance without a prescription, submit to random PVTs and urinalysis. There is a cost that may be associated with that. That's usually what I violate people on, is that they drop dirty and then we deal with the consequences. You understand that? I've set it up front. It's your chance to really show off a little bit. I'm not doing that as a part of probation. No bars or nightclubs is a good idea. Moral recognition therapy is ordered at the request of probation. I'm going to order that usually that's a 2-day class, if not long. I think it's 2 days class. So moral recognition, obtain and maintain employment, which you're already doing, and not purchase or possess firearms, ammunition, or weapons of any kind as a part of the general probation orders. I do that on every case. So it's a pretty straightforward probation. Don't drink, don't do drugs. You'll be done with probation in 8 months. It's all via Zoom. And then you can put this behind you and say, this is a successful probation. Anything towards the judgment of sentence, Mrs. L.
No, Your Honor, thank you.
Mr. Annette.
Mayor, thank you.
All right, Mr. Ayers Ellis, good luck to you, sir. Okay. All right. Thank you. I don't think that one has to be prettied up unless they can't read my number.
Your Honor, does he goes back to Mason, then gets released?
Yeah, he gets released from Mason.
Today, you think?
Yeah.
Today?
Yeah, should be, it should be, and there should be no GPS or no contact order. So he should be able to be released tonight.
Thank you so much.
You're welcome. All right, so we have Gonzalez and Ray. Let's go ahead and call Gonzalez. Is there Malai Gonzalez here? Is there a Caleb Ray here? All right, let's call those two and then we'll be done with our 130s and maybe we can see how many civil stuff we can get to because I don't know.
Oh, that's what I want to bring up, Your Honor. I have not submitted my jury instructions and I don't think I'm gonna have time to. Did you? Okay.
Yeah. Well, let's do it. Let's go on Gonzalez, and we can. So we're on the record in docket 24-02026. That is people, the state of Michigan versus Malaya Gonzalez. This is the time set for sentencing on a probation violation matter. It was scheduled for 1:30. It is now 4:40. And it would appear that the defendants failed to appear for the sentencing. I do not see a Malaya Gonzalez in the Zoom courtroom or physical courtroom. Nobody is by that name in the hallway. Mrs. L, how did you want to proceed today? It appears the defendants failed to appear for sentencing.
Your Honor, this is for Malia Gonzalez, correct?
Correct. Malia Gonzalez, and I don't think we even have, I think she absconded from bond too.
I believe this is a probation violation arraignment.
Is it? All right. Let's see. I think you're right.
Yes.
All right. So it appears the defendants failed to appear for probation violation arraignment. And the court for not appearing on the probation violation arraignment, the court will issue a bench warrant and bond forfeiture on Ms. Gonzalez for the fail to appear for arraignment. I do not see Malia Gonzalez or Malia Gonzalez in the Zoom courtroom or physical courtroom, and therefore we will issue a bench warrant for her non-appearance for the probation violation arraignment. The defendant had previously absconded from probation, and we don't have an updated probation report, hence the allegations. All right. All right, so that's all for the record in 24-02026. And then how did you want to go on Mr. Ray? Should we just reset that or?
This is the second time that he's failed to appear for this specific.
I have him in custody.
Is he in custody? Because
they did a writ. I'm not saying he's still in custody. At one point, there was a writ done.
So is he in custody in a different county?
Yes.
Okay.
Yeah, I have him writ out for probation violation hearing.
Then yes, Your Honor, I would just be asking for this to be reset.
I'm just trying to figure out of the Eaton County Jail. So I have him, is that the last, your place of, so I have a violation of probation on him, and then I don't have, I have a writ done out of Eaton County on June 1st. All right, so let's do appearances for the record. So we're on the record in docket 24-03510. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the People.
Mr. Annette.
George Annette, APD, on behalf of my client, is not present today, Your Honor.
All right, so this was set for probation violation. And this defendant was writ out of Eaton County June 1st of this month. I'm assuming he's still in Eaton County. So did you want it, should we just reset this and then we'll try to figure out where he's at? Because I don't know if he's even in Eaton County now.
I believe that would be the best way to go, Your Honor. I have no way of really seeing that, so
Right.
I think it would be best to figure out where Mr. Wright is.
We'll do the writ once we figured out where he's at, but we'll set it for about 30 days from now. For sentencing.
Either of you should look and see if you can get in a binding. I just can't.
Well, Mrs. L can't.
I'm wondering if the writ wasn't done in time. And
I don't know. This writ was signed June 1st for June 17th.
Oh, okay, never mind. Maybe he got out.
That's my fear. My fear is that he's not here. He got out. We don't know where he is, but we can figure that out. We just have to set a date and then figure out where, if he's out, we've lost contact with him.
I tried to call him.
Yeah, and then if he's in, we can writ him out. So we'll set date for 30 days out for
July 15th at 1:30.
July 15th at 1:30. All right, so we adjourned the sentencing to July 15th at 1:30. In the meantime, Mr. Nett, if you having any contact with him, you can let us know. If he's out, that'll be the date he's to show up at. If we have to writ him out, we'll set it for July 15th, that very same date. Anything else for the record in 2403510, Mrs. L?
Not for the People.
Mr. Annette. Okay, you're all set. Thank you for your appearance.
Jury instructions. Your Honor, can I turn those in tomorrow?
Yes.
Do we have an extension till 10 a.m. tomorrow?
Yeah, 10 noon, just get them in tomorrow. All right. Let's see.
I sent
Mr. Bach, what cases did you have left? We'll try to get any no-shows done in the next 15 minutes.
Yes, I've got two left. They're both LAFQ. One is Ajayi Perkins. The other one is Jordan Mata.
Okay, I don't see Jordan Mata. Is Jordan Mata I don't see Jordan Mata here. I don't see Ajayi Perkins in the Zoom courtroom. All right. So that would appear that both of those have failed to appear.
Let me know if
Let's call those cases. So that'd be 1-6. I think I have files for those. 161686. All right, so we're in the record in 1601686. That is LAFQ versus Jordan Mata. Will the parties please introduce themselves for the record? Mr. Bach.
Yes, good afternoon, Your Honor. Ronald Bach here for the plaintiff LAFQ.
All right. This time set for a discovery hearing. This was scheduled for 3 o'clock. It is now 4:47. It would appear that the defendant has failed to appear for the discovery hearing. I do not see a Jordan Mata in the Zoom courtroom or the physical courtroom. Nobody's answering by that name in the hallway. Mr. Bach, how would you like to proceed?
Well, I did see his name on the Zoom call earlier, so I think I would request a show cause at this time.
All right.
Then hopefully you won't have such a crazy day that day.
Yeah, let's hope. So we'll set for show cause hearing. And we don't schedule that, Civil does, right? Okay.
No,
And
I'll
you'll get
have
that scheduled. That
I'll have
you'll
our
get that
office file.
scheduled. What's that?
I'll have our office file the show cause.
All right. All right, we'll set it for show cause hearing and we'll wait to hear from you. Anything else for the record on 1601686, Mr. Bach?
No, Your Honor.
All right, and then we have docket 1601798. And that is Lafque versus Ajayi Perkins. Appearances for the record, Mr. Bach.
Yes, good afternoon, Your Honor. Ronald Bach here for the plaintiff, Lafque.
All right, this is set for discovery hearing. I do not see an Ajayi Perkins in the Zoom courtroom. I don't know if they were previously in the courtroom, but I don't see him now. There's nobody by that name in the physical courtroom. It would appear that the defendant has failed to appear for the discovery proceeding. Mr. Bach, how would you like to proceed?
Let's just be consistent and have plaintiff file a show cause on that one as well.
All right. So we will set for show cause a hearing and await in order to follow.
Thank you, Judge.
We should be all set on 1601798. And then we had a 1601786, but that was taken off the docket. Is that correct, Mr. Bach?
You know more than I do. It was
Okay.
That's all. That's everything on my list.
All right. You're all set. Thank you for your appearance.
Thank you.
All right. And then do we have a representative from Absolute Resolutions? Or is that Mr. Fay? Is that your case?
That is, Your Honor.
All right. And is there a Manikshi Simmons here? All right. Ms. Simmons, you can come up here. All right, so we're on the record, and you can have a seat, ma'am. We're on the record in docket 2500824. That's Absolute Resolutions versus Manikshi Simmons. Will the parties please introduce themselves for the record? Mr. Fay.
Good afternoon, Your Honor. It's Craig Fay, P8140 on behalf of plaintiff.
All right, and ma'am, you are, and correct my pronunciation, Manikshi Simmons.
Meenakshi's Your Honor.
Meenakshi Simmons, thank you. All right, this is the time set for a motion scheduled today. I have it for a motion for summary disposition. I don't know if that was filed or not. Mr. Fay, how are we proceeding today?
So we did receive payment from Ms. Simmons. It looks like it was received on June 10th. We're just waiting for that to clear. It looks like it did. So at this time, we can submit a dismissal with prejudice under the 7-day rule if the court will allow.
All right.
We can mail a copy to the defendant for her signature.
All right. So order to follow concerning the dismissal. It appears, so Ms. Simmons, I don't know if you heard Mr. Fay, but it appears that payment's been made and a dismissal is being forwarded. Mr. Fay is going to forward that to the court. And once I verbally say something, that means it's ordered, but it really doesn't count till I sign the paperwork. All right. So I will sign it when it comes to electronically filed. And Mr. Fay, you'll sign that you'll send that sometime tomorrow morning, I would think.
If we need to submit it by the 7-day rule, or just submit the order directly by my file.
Okay, you do it by my file. Once it's an indication that the payment's been received. So once I sign the order, once you submit it, you place it on the record, we should be all set.
Okay, perfect. I'll have that. I'll draft it now, and it should be filed tomorrow.
All right. Anything else for the record, Ms. Simmons, or do you have any questions of me?
I don't believe so. We paid on the 10th, and I don't know if this is the place for it, but I'll say that working through the company and their representatives has been extremely difficult just to get contact information or to even pay them. I feel like it was more difficult really than it had to be. And despite trying to communicate with them, which they said to reach out, communicate with them and send them the things that say that my only income is veterans disability and Medicaid and things of that nature,
it was still made very difficult.
All right, all right. This case has been dismissed. That's all been placed on the record. It's recorded. Um, I don't know what agency would follow up concerning any problems or indications you might have, but I will await the order to sign. All right, ma'am? All right. Anything else for the record in 2500824, Mr. Fay?
No, Your Honor.
All right, you're all set, ma'am. Thank you for your appearance.
Your Honor.
All right, and Ms. Hart, are you here for Baltic Flats?
Yes, I am, Judge.
I think we're just making it under the just making it under the 5 o'clock. You know, this building shuts down at 5 o'clock. That's what they say.
Oh.
I don't know if that's true or not, but it might. We're testing it. We're testing it right now. All right. Okay. My staff tells me there's a trial going on.
I completely understand. No problem.
We're I think we're gonna get through this. All right. So we're on the record in 25-01194. That's Baltic Flats versus Sharon Ferris and Latovian Knight. Appearances for the record, Ms. Hart.
Good afternoon, Your Honor. Sumchit Hart, P69542 on behalf of Baltic Flats.
All right, this is set for a motion to evict, and I do remember this this was from a consent judgment on one of them, or a conditional dismissal, and then you had to decide if you were going to file a default on the other. Is that correct, Ms. Hart?
Judge, this was actually a case where the 56 days lapsed. We were trying to work with the tenant in order to have her become current. It was a default as to defendant 2, consent as to defendant 1. In a regular judgment, not a conditional dismissal. They did pay $1,450. So that wasn't the total redemptive amount that was due by the 30th of April. In addition to that, they've stopped making payments altogether. We do have a balance right now of $3,527.66. We're just asking that the writ issue for their failure to comply with the judgment.
All right, I do have the motion for eviction pursuant to MCR 4.201. And I think I can, if you followed up with an order, this is just the motion. And so 56 days has elapsed. So you can indicate that I have granted the motion to reapply in the 56-day rule, and then for order of eviction under past, and I think it would be immediate, but it'd be 10 days from the date of signing. Is that correct, Ms. Hart? I'm not sure on.
I think
on
it could be immediate, Judge. After I think it can be immediate. Correct.
All right. All right. So I will sign for the non-appearance. This is scheduled for 3 o'clock or 2:30. It is now 4:57. And it would appear that the tenants D1 and D2 have failed to appear. For the motion. I do have the motion. I'd have the order. The terms have been placed on the record. And you will submit an order to that effect, Ms. Hart.
Absolutely, Judge.
Have you had any contact based on the consent judgment with Ms. Ferris or Mr. Knight? And Knight was, I believe Mr. Knight was part of the default, wasn't he? I can't remember.
I believe that
Ms. Ferris was present, and then D2 was not present. And then, so the consent judgment was on D1 and D2 was was defaulted.
Correct.
All right.
So the last contact we had, she stopped paying, and that she paid a total of $1,450. After that, she stopped contacting the office, Judge. So.
All right. All right. So the terms have been placed on the record. The orders to follow concerning the 56-day rule and the eviction.
Thank you, Your Honor.
you should be all set. Thank you for your patience today.
Absolutely,
We'll see you
Judge.
next time, Mr. Hart. Ms. Hart.
See you soon. Bye.
All right, bye-bye.